I declare open this hearing of the Senate Economics Legislation Committee into the 24-25 supplementary budget estimates. I begin by acknowledging the traditional custodians of the land on which we meet today and pay my respects to their elders past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples here today. The committee has set 28 November as the date by which senators are to submit written questions on notice, and 9 January 2025 as the date for the return of answers to questions taken on notice. The committee's proceedings today will begin with APRA. Under Standing Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. The Senate has endorsed the following test of relevance of questions at estimates hearings. Any question going to the operations or financial positions of the departments and agencies which are seeking funds in estimates are relevant questions for the purpose of estimates hearings. I remind officers that the Senate has resolved that there are no areas in connection with the expenditure of public funds where any person has a discretion to withhold details or explanations from the Parliament or its committees unless the Parliament has expressly provided otherwise. The Senate has resolved also that an officer of a department of the Commonwealth shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Witnesses are reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised. I incorporate the PII statement into the Hansard. I remind all senators that as we continue our work implementing the Set the Standards report, I will ensure that proceedings are conducted in an orderly, respectful and courteous way. The committee has agreed to authorising media outlets to record the proceedings, etc. An officer called to answer a question for the first time should state their full name and the capacity in which they appear. I remind committee members and witnesses who are appearing via video conference and who are not speaking to please mute their microphones. I now welcome Senator the Honourable Tim Ayres representing the Treasurer, and I also welcome representatives from APRA. Welcome Mr Lonsdale, welcome Ms Beverly Smith, and I see that you've given us an opening statement. Would you like to speak to it briefly or proceed straight to questions?
Thank you, Chair. So I'm happy to table the opening statement. I would like to make just one comment. Less on the statement, more on the logistics. So for the committee to note, we have found the logistics to be here tonight quite difficult, and that's why I'm the only APRA member able to be here tonight. So you have me. We have several travelling overseas on international standard setting meetings and could not be here. I want to assure the committee, though, that we take our responsibilities to the Parliament and to the committee very seriously, particularly the accountability part, and we'd like to work with the committee to make sure that we can ensure next time we're all able to be here.
Thanks, Mr Lonsdale. I'll go straight to questions. I'll go to the Deputy Chair, and I will table your opening statement. Thank you.
Thanks very much, Mr Lonsdale. I have some questions about superannuation tonight. Can I ask you, were you aware of the independent review undertaken into the CBUS Super Fund by former ACCC Chair Graham Samuel?
I am aware of a report, yes. A very dated report, I think, if it's the same one that I think you're talking about.
Yeah, it was a review into the governance of the fund about 10 years ago.
That's the one I'm aware of.
Yeah, so you're aware of it, and are you aware of the recommendations?
No, I've not read the report.
Okay, but does APRA have a copy of it?
I believe we do have a copy of the report.
Okay. These matters to do with this fund was discussed at the Royal Commission conducted by Ken Hayne, and the counsel assisting Jeremy Soldier said in relation to this fund, quote, it was infected by the separate private interests of the CFMEU and a deep-seated loyalty to those interests. And then Soldier went on to say it was so divided in interested in genders, it poses particular governance challenges in a modern environment. So that's what Soldier said, and Graham Samuel made similar comments, and he recommended there be changes to the board composition of that particular fund. Do you have any insight into why those recommendations or why these issues haven't been progressed?
No, Senator, in the sense of the remarks that you're talking about and the report itself. As I said, it's quite a dated report.
Yeah.
I've not read the report personally. What I can say, though, which is a matter of public record, is the fund in which you're speaking about is a fund that is under scrutiny by APRA at the moment.
But effectively, you have commissioned a governance review. Is that right?
So we have, this is in respect of CBUS.
Yeah, CBUS, yeah.
So we issued a press release, you'll be aware, Senator, where we imposed some licence conditions that went to the fitness and proprietariness of board members and also the BFIT itself. That is a process that's currently underway.
So is the scope of that work to look at the governance arrangements of the fund in terms of ownership and board composition?
The scope of that, as I understand it, by an independent party, we've asked for a review.
By Deloitte, right?
Well, that's not something we have publicised. What we have said, Senator, is that there is an independent party looking at this, but it will look at the fitness and proprietariness of board members. As far as I'm aware, not the governance more broadly.
Okay, so the issues that were flagged 10 years ago by Graham Samuel about a lack of independent directors on these boards, for example, won't be looked at by the Deloitte review?
As I said, Senator, it is quite specific on the fitness and proprietariness of the board.
Of the current directors or the proposed directors, or both?
Both.
Both. Okay, so what happened yesterday? My understanding is that 3 new directors were put onto this board, and you have released a statement saying that you are still considering your position on whether these are appropriate persons, or what is your position in relation to yesterday's developments?
So we think our position is clear, Senator. So we have, as I said before, put licence conditions on the fund.
Yep.
That involved an independent party examining the fitness and proprietariness of directors and the BFID. As I sit here before you, we've not seen that independent report. And so the licence conditions that currently apply to CBUS still apply and are not resolved. That is our position.
It's unresolved?
Yes, it's unresolved.
Including the appointment of these new people?
Well, we need a fitness and proprietary test to be applied. That is the licence condition that applies, Senator.
Okay, and so you can't resolve this matter until you see the report, or how will you resolve it?
So one step at a time, we need to see the report and we need to make sure the requirements that we require are satisfied.
How do chairs of these super funds usually get appointed?
How do chairs of
Well,
when you
how do
say
become
these super funds?
How do you become a chair of a super fund? Usually in industry practice. I mean, I'm just wondering, Mr. Swan's been appointed the chair of this fund. How do you think he was appointed? Was he the best person for the job? I mean, do you have any sense of what process the board went through?
I can't comment on that, Senator. I wasn't close enough to that appointment. But what I would say is we have a set of standards that apply. We expect those standards to be satisfied. I can also tell you that we do not have the powers to either say a person should not be on the board or to veto or take somebody off a board. That is clear.
So if a person doesn't pass the fitness and propriety test, then what happens?
Then they would not fulfil the standard.
So you do have the power.
Well, we would say to the board that they need to satisfy the standard, and if they did not satisfy the standard, we could issue a direction.
Okay. So a person needs to meet that test.
Well, we would. That's correct, Senator. We expect people who are fit and proper, who have integrity, who are honest, who can manage conflicts. There's a whole list of requirements that we expect to sit on a board.
Okay. Have you asked for the Deloitte report?
Have we asked for the
Yes.
Deloitte report? So
Have you asked for that Deloitte report into CBUS?
Well, it's an expectation that we would be provided with the report once the report is complete. And my understanding is that our supervision team is talking not just to the entity, but the reviewer as well.
Okay. Well, I just want to read out a media release from yesterday, 19th of, is that right? 19th of November? 2 days ago, from the CBUS website. And it says, I'll quote it to you so it goes into the record. It says, all existing and new directors on the CBUS Super Board have satisfied a fit and proper persons test as part of an ongoing independent review being conducted by Deloitte at the direction of APRA. So what does that mean?
Sorry, what
Well,
was the
I'm wondering
question?
what you, as the regulator, what you make of this very strong statement by the fund, which is from its website from 2 days ago, that it's declared that its existing and new directors have met the fit and proper persons test as part of the ongoing independent review being conducted by Deloitte at the direction of APRA.
Yes,
So
Senator.
what do you make of that?
So what we made of it was the press release that we put out on the same day, Senator. It's a matter of public record. So what we said was we have not received an independent report.
You haven't received it.
No, we have not received an independent report, and because we have not received it, we think the licence conditions have not been fulfilled.
Okay.
And that's very clear, Senator. We're very clear on the public record.
Okay. So the fund's declaration that it has met a fit and proper persons test is actually not a test that it can declare that it has met itself, though, can it?
Well, ordinarily, an entity would apply the fit and proper test themselves. In this particular case, though, as I've outlined, we have imposed licence conditions that requires an independent party to do the test, to do a report, to give us the report, and not only give us the report, make that report public. That's our position, Senator. I think it's very clear.
So you expect the Samuel report, sorry, not the Samuel, you expect the Deloitte report to be made public?
Correct, Senator. It's part of the conditions.
So why do you think that the Samuel report wasn't made public? Because it wasn't commissioned by APRA, perhaps?
Well, Senator, you're asking me to go back a decade. I've not seen the report. My understanding is the report was commissioned by the entity itself.
Well, I suspect it will traverse a lot of the same ground. Okay, so, but thank you for clarifying that, because it wasn't clear to me exactly what had happened there. So when do you expect to receive the Deloitte report?
So I'll check, do we have a date?
We don't.
We don't have a date.
But they've already put out a media. They've already put out a media release about it. They've already put out a media release about it. So don't think that's strange.
Well, Senator, yes, I know CBUS have put out a media release, and we've indicated in our media release a different set of facts, and we've put that on the public record.
Okay. I want to take you to your... Thank you for clarifying that. So sorry, let me just clear this up as well. Do you expect to receive the report from Deloitte at the same time that it is made public? Or would you expect to be able to inspect the report before other people are allowed to consider the report?
Well, I would expect it that it would be provided to the regulator first, and then we would make it public. Then it would be made public. That would be my expectation.
Okay. And if your judgment is, so this is only about fitness and propriety, it's not about anything else. So if your judgment is that there are persons that do not meet that test, then what is the next step? Do you go back to the sponsoring entities, or you go back to the board and say you need to find new people?
Well, it is a complex set of issues because there's an administrator as well. So the way I'd prefer to answer that question, Senator, is just one step at a time. So let's get the report first. Let's find out what is in the report and what are the facts, and then we will make our decisions based on that.
Yeah. I just want to take you to some of the very clear statements in the Prudential Standards. And as you know, the Prudential Standards are a significant delegation of parliamentary authority to the regulator, which means we give you because we think that you are in the best place to subordinated law and then enforce those laws in your role as a regulator. And going through the SPS 510 governance prudential standard, I thought there were very clear statements there, which I'll just read into the record, in relation to the role of the board. So the board is ultimately responsible for the sound and prudent management of an RSE licensee's business operations. And then another one, the board cannot abrogate its responsibility for functions delegated to management. So the board is accountable, isn't it?
Yes, Senator.
Okay.
Ultimately accountable.
Ultimately. So the chair of this fund gave a television interview on Friday where he said that, quote, the cause of this, and I'm talking about this insurance issue that's being pursued by another regulator, the cause of this lay principally with a third-party operator. So, I mean, what do you make of that? Is that the sort of accountability you expect of a board?
Well, Senator, I don't particularly want to comment on the actions of another regulator.
I don't think. I mean, I don't think that you can really expect Mr. Lonsdale to be able to answer questions in relation to the other regulators' engagement. And I'm listening carefully to the questions, but I haven't stepped in thus far, but asking Mr. Lonsdale hypotheticals or questions that go to APRA currently exercising its functions, have to be done carefully.
Okay, well, fair enough. Who is responsible in an RSE for appointing material service providers? Because the super funds are effectively like shell companies. They don't really do many things. There's a trustee, a few people rattling around a building, and then investment management's, generally speaking, run by someone else. They don't do insurance. They don't even do administration. So they don't do many things. So who is responsible for appointing service providers?
So maybe I could answer the question in a general way,
yeah,
Senator, and maybe this will help. So we have another standard. We have a lot of standards. We have another standard, CPS 230, which will come into effect July 25. So it's a new standard. It talks specifically about the provision of third-party and, in fact, fourth-party providers. And the general principle in that standard is that although the service can be outsourced, the accountability can't be outsourced.
Right.
So entities, whether you're a bank, whether you're an insurance company, whether you're a superannuation fund, need to ensure that when they're outsourcing that they have that they have risk covered and controls covered.
Yeah, I used to be an internal auditor, so I used to write those internal audit reports.
Just last question, Senator Bragg.
So can you just say that again? You can outsource functions, but you can't...
Well, the accountability lies with the entity. So because you outsource the function to an entity that we don't regulate, perhaps, if something goes wrong, if I can put it this way, we will come and talk to the entity.
So...
Thank you. Senator Sheldon.
Thanks, and welcome tonight. And thank you for joining us.
Pleasure.
At least there's two of you. Just a few questions. I've got a couple of lines of questions, and we'll see how we go with timing. And I've got many more questions which I'll probably need to put on notice, and also some other matters I'll need to follow up following that. Does APRA have a governance policy in place about people working at the regulator, and particularly senior figures leaving the regulator and joining a regulated entity in quick succession? And is there a policy in place to prevent conflicts of interest in that regard?
So, Senator, in broad terms, yes, but it does depend...
No, raw terms. Can you just give me, not too much detail because it's the time of the night, but what terms have you got? Raw terms? What's raw terms mean?
So, if I just... So it depends. So we have members, if I can just put members to one side, so they are appointed by the Governor-General for a term. And
also
then,
senior executives. Just move there first.
So
I'll do follow-up questions on the others.
So if we have senior executives, so there is usually a notice period when we become aware of an individual that has accepted a job with another, particularly with a regulated entity.
And what's that notice period, just to clarify?
So it depends on the contract, but it could be 6 months. It could be
6 months.
It could be 3 months. It depends on the contract.
Or 3 months.
I'm happy to come back to you with a more authoritative response.
No, you're helpful.
There is a period. If they were leaving, the normal course would be if they were leaving for a regulated entity, then they would be immediately put on what we'd call gardening leave. So they would no longer be working on frontline issues, on entity issues.
Just so I can understand that, so probably easier for me to unpack it. So I'm not meaning to keep answering the first question, but I've just unpacked it a little bit. So if you found someone who's going to work somewhere else that's a regulated entity, you just put them on gardening leave, which give them other jobs to do, which could be with other regulated entities or with policy areas, or gardening leaves, stay home, get paid, don't do anything.
So it could be the latter, but it could be the former too, in the sense it wouldn't be a regulated entity set of issues. It could well be an internal set of issues, so completely removed from the population of entities that
Or couldn't be. So it's a decision of the chair, is it?
It's a case-by-case decision, and there are people who leave. We do have a lot of people in APRA who do not have frontline responsibilities.
So they would be allowed not to talk to anybody else, a bit like PwC, like you're not allowed to talk to anybody else.
They'll be quarantined.
There might be conflicts of interest.
Yes, certainly, and we have a very strong conflict of interest policy.
I just want to be clear, because I did ask about the connection with PwC. It's similar to PwC. You would not be able to, you'd have like walls between people, a bit like PwC.
Chinese walls.
You mean once they're leaving?
Once you become aware of the fact that they might be still working there whilst they've applied for a job or been approached for a job and considering a job with the body that the APRA has been regulating, not only themselves involved directly, but APRA is regulating.
Yeah, so usually we would not know if they're being courted for a job. Sometimes we do, but it would be at the point at which they accept a job where we would know.
So there's not an expectation for them to tell you if they've been courted for a job?
There's an expectation that if they are aware of a conflict...
No. I'm asking you about specifically about being courted for a job.
So we rely on our people. We have a strong conflict of interest policy. We have processes in place. We rotate people to make sure that we minimise conflicts of interest.
No, I'm talking specifically about someone being offered a job or being offered a job. And do they have to notify you as the appropriate officer that they've been offered a job?
If they've been offered a job and accept the job...
Only accepted, not offered.
Well, I don't think there is a requirement, Senator, to inform me if they have been offered a job.
That's helpful.
But if I could just finish, if there is any conflict or perceived conflict, we expect our people to manage that. And
if someone offered somebody a job from, I don't know, just pull a figure out of the air. I'm going to pull a figure out of the air, $10 million, and says, I'm offering you a job for $10 million to come and work for me, and APRA is actually investigating that body, and that person doesn't tell you they've been offered, which I think is an extraordinary amount of money. I'm not sure if you think that's an extraordinary amount of money. I do. And they're considering it, but haven't actually said, I'm going to consider that job, or I'm going to take that job, or I might take that job, or let's have another meeting. All of those scenarios are not required to actually tell you.
No, well, in that particular example, I would say that's not just an actual conflict, that's a perceived conflict. Right? That is a perceived conflict. I would expect that to be raised.
What happens if they're offered $1 million or $100,000 or...
Well, it doesn't matter if they're offered $1.
Yeah, righto. Now, let's say that they're offered a job without dollars attached, but everyone knows it's actually worth considerable amounts of money.
Well, we're getting into... So,
no, it's not a hypothetical. That's actually how jobs are offered.
Yes, Senator, and what I'd say is I go to the conflict issue, I go to our values, I'm going
to go back to your earlier answer.
Senator, can I just finish?
No, you're not going to avoid my question. I would like you to go back to the previous answer you gave, just so I'm clear. I'm not putting words in your mouth. I'm more than capable of saying whether I'm right or wrong, and I'm very respectful of the fact that tell me whether I'm right or wrong. You've said, as I understood the evidence you just gave, and that is that people aren't required to turn around if they're approached about a job, that they have to notify you. It's only if there's a conflict, which I'm trying to clarify what conflict, not only conflict is, but do they have to notify you if they're offered a job?
Senator, can I just...
I'd like to know what you do.
Good, and let me explain it to you.
I'm very looking forward to it.
Will you let me explain it, please?
Yeah, you have the call, Mr Lonsdale, and I'll let you finish.
That would be good. So, in APRA, we have a set of values. They're very important values. We expect all our employees to satisfy those values. We have a code of conduct that includes the values: integrity, collaboration, accountability, respect and excellence.
Like PwC, yes.
Mr Lonsdale, you have the call.
Well, Senator, I don't want to comment on PwC.
I'm asking you to comment on PwC.
Senator Sheldon, I've indicated that Mr Lonsdale will be given the opportunity to answer your question. So, Mr Lonsdale, you have the call.
The values are embedded in the code of conduct, and we expect people to act ethically at all times.
Can you give me a copy of the code of conduct? And that would be very helpful for the committee.
That means
can I just, sorry, Chair, I would really like a copy of the code of conduct. You can give me it to me. You can put it on Hansard. It'll be publicly made available. So I've only got so much time. I do need to ask you questions.
Chair, I've been asked a question. The Senator is not allowing me to finish the answer.
I agree with you. You have the call, Mr Lonsdale.
We expect all our employees to act ethically. I've talked about conflict of interest. I've talked about disclosing financial holdings. If there are any gifts or hospitality, we expect those to be declared. We expect reporting of incidences and breaches, and we expect security. There's a whole list of issues that we expect in the Code of Conduct, which I'm happy to table. Thank you.
Thank you. If you tabled it, it would have saved us a little bit of time, but that's okay. Please table it. Now, I just want to go to then, I understand that former APRA Chair Wayne Burns joined the board of Macquarie Bank, an entity he used to regulate less than 18 months after he left APRA. Before Mr Burns left, did he ever disclose that he was looking at or was interested in working in Macquarie Bank or another regulated entity or offered a job?
So I'm assuming you're talking about Wayne Byers.
No, that's him, yes. Go for it.
So, Senator, as I started answering the first question, you can split the senior leadership in APRA between the senior executives and the members.
Yes.
Mr Byers was the former chair of APRA.
Yes.
He's appointed by the Governor-General
Yes.
for a term.
Yes.
As I'm aware, there are no requirements specified by the Parliament or by the Governor-General following the departure of a member. Having said that, we have employed a convention where members who leave APRA's employment would not go onto a board or employment for a regulated entity in a regulated entity for a period after they leave APRA. And in Mr Byers' case, I'm fairly certain that he did not take up a board position on a regulated entity within 12 months of leaving APRA.
So, I go back to I appreciate you've given us a very clear answer, and thank you for that. And that is that there's convention rather than if I understand, convention rather than requirement. If I got that right or not?
That is of our own volition, I want to add, right? That is not, these appointments are not made by APRA. These appointments are made by the Governor-General.
I was asking something slightly broader than that. Is there a convention regards executive officers? There's only a convention regards the chair, just that they don't.
Are you talking about APRA members, including the chair?
Yes.
Any appointment by the Governor-General, so at the moment there are 4 members.
Yes.
We would expect, as I just outlined, that there would be a period following the departure. Well, in Mr Byers' case, there was a period of 12 months.
And others?
Well, I think, Senator, they vary.
Deputy chair, for example.
They vary. Well, that broad convention would apply to them all, but if you were asking me for every member that has been in APRA, did they observe the 12 months? Well, we'd have to go back and look.
All right, so not clear about the convention. If you can take that on notice about the convention that you've applied to, at least the deputy chair, the most recent deputy chair and chair would be helpful. I also understand that Mr Byers was 56 when he announced he was stepping down from APRA, so it's not surprising he might be looking for other work. But he never mentioned to anyone on the APRA board or executive he was interested in looking at working for a regulated entity. Is that correct?
Well, I'm not aware of that, Senator. I wouldn't expect him to discuss his future career plans 12 months on from APRA. I'm not aware of that.
Could you also take that on notice, whether that was communicated with any other people within APRA as well?
Well, I'm not sure how we would find that out, Senator.
I'm asking you to ask the question. I'm sure you'll do your best endeavour.
Happy to take the question on notice, Senator.
So he didn't say to the entire team, as far as you know, about the fact that he was going to work and had been offered a job with another entity, that there may be a conflict of interest?
Well, I can't see how he could have, Senator,
okay.
because my understanding at the time, and we're going back over 2 years, was Mr Byers' term expired and Mr Byers left to pursue another career.
Thank you.
And did not take up a role, as I said, with a regulated entity within 12 months of departure.
Thank you. According to the financial reviews, it goes back to that earlier questions I was asking about, people considering what their future is. Somebody is 56, how long they're going to stay at the board. I mean, that would be a normal conversation that would happen around boards, but you're saying that implying that that doesn't, I'm sorry if you're actually saying it, but implying that didn't happen within the board, about what the future holds and what, you know, where somebody wants to go somewhere else. And 56 is not an unusual age for someone to think about other career opportunities, but I'm saying that I'm just raising that sort of colloquial sort of pub test about conversations that happen around boards. But according to the financial reviews coverage of the announcement...
Can I just clarify that?
Sir, absolutely.
Because the appointment process for members is on a term basis, usually 5 years. So it is very clear, usually, that there is a term that is about to expire.
Yes.
So...
Mr. Alonso, can I just put to you then that the term's about to expire, you would think that conversations would be taking place within 12 months. I hope that's part of the convention you mentioned. What are you planning on doing? And by the way, here's conflicts of interest, potential conflicts of interest. But even not just that formal, there'd be conversations taking place about what's your next step. Do you want to go keep on the board? If you weren't to keep on the board, where would you go? Wouldn't you think that that would be a pretty regular conversation or normal human interaction?
Senator, the appointment process, as I understand it, is made in APRA's case by the Treasurer. So it's not a decision that is made by the APRA board.
I'm not saying about the decision, I'm asking about the conversations.
No, but it is important because I think what you're implying...
I'm implying nothing, I'm asking questions.
Well, if you're asking a question, the answer is the Treasurer makes a recommendation to the government that is then put to the Governor-General for the appointment of APRA members. That's the fact.
I'll share the call. Senator Bragg.
Thanks very much. So I was just asking you about the issues in relation to the engagement of service providers. So effectively, if you are a board, does the board sign off typically on material service providers? So I won't give you hypotheticals, I'll give you a real example. In the case of an RSC, a super fund, if they're engaging an investment manager or an insurer or an administrator, is that a judgment of the board?
Well, I'd have to come back to you on that, Senator.
Okay. Surely if a fund was making a decision to engage a life insurer and it had a large MySuper portfolio, I would imagine that would be a material judgment for that fund, would it not?
Yeah, I would have thought there's all sorts of outsourcing that happens in a fund or an insurer or a bank, from little outsourcing to major decisions, as you say. And the more significant the decision, the more the involvement of the board, I would have thought.
Okay. So let's just go back to the sort of the internal audit function issue. So when you look to perform compliance checks with the prudential standards, do you ask for a risk and control matrix?
Can you comment on that?
Senator, can I ask you if you could give me a bit more specificity to your question?
Well, of course I can. If I go to SPS 510 governance, and I look at the internal audit section, which sets out, and I'll read into the record, an RSC licensee must have an independent and adequately resourced internal audit function. Okay, so they must have an internal audit function. Does that mean they can get an internal audit function from their internal resources, or do they need to bring in an external body to do that?
So funds have a choice as to whether they have an internal audit function or they outsource that.
Okay. And so they'll go through and they'll look at their risks and their controls.
The internal audit function, yes.
Yeah, okay, that's as I imagine it would be. And then what do you seek? Because then your prudential standard goes on to say the objectives of the internal audit function must include the evaluation of the adequacy and the effectiveness of the financial and risk management framework of the RSC licensee. So when I did an internal audit that was a risk and control framework. It wasn't very exciting, but it was a good way to catalogue all the different risks. So would you ask for that?
So in a supervision engagement where we're focusing on risk and compliance capability, we would ask for a range of things from an entity. That would include frameworks, policies, examples of risk and compliance matrices, controls testing, a range of things we would test to determine whether the risk and control frameworks are adequate and in line with our expectations.
Okay, so do you stress test them all on some sort of a cycle?
So we don't replicate an internal audit function, Senator. What we do is we would usually pick a particular scenario and run it through a risk and control scenario with an entity in order to test the strength and resilience of the frameworks.
And what do you do for the super funds that have group insurance as a service provider? What sort of tests do you put them through from a prudential point of view?
So the kinds of, so I can't be specific, I can be general in terms of what we would do. So we would look at whether the entity had clarity on end-to-end processes, whether the entity was clear what controls are in place to manage the risks inherent in the end-to-end process, regardless of who performed the steps in that end-to-end process. So that would be the kind of engagement that we would undertake.
Okay. And there is a prudential standard for insurance, isn't there?
There is.
For group insurance?
There is.
Okay. And does that include obligations for the board to appoint a group insurer? Or is it more operational than that?
It's more operational.
More operational than that. Okay. So do you have a view on so-called profit-sharing arrangements that sometimes happen between the group insurer and the super fund?
I'm not aware that we do, Senator.
So you don't, it's not something that's captured by the standards?
No.
Okay, so but if there was a profit-sharing arrangement, and I'll explain it for the record, so profit-sharing arrangement might be a case where the super trustee has an arrangement with the insurer where if there are fewer claims paid by that super fund, then there is a financial benefit to the super fund itself. So that's not something that you'd manage in this standard making process.
So it wouldn't be covered in the standard that you're referring to. I absolutely would expect it to be covered under an entity's obligations in terms of the best financial interests of members.
Is this something that you think happens in the Australian market?
I don't know if I can answer that question, Senator. I'm not aware of it happening.
Well, you don't have that many options at estimates. You either say you don't know or you take it on notice, or you give the answer.
Sorry, Senator.
Sorry.
I'll take it on notice.
You take it on notice. So you're not sure whether...
I'm not sure.
You're not aware of that, Mr Lonsdale, either?
Well, as I said, Senator, we'll take it on notice.
Okay, that's fair enough. I want to take you to this... Are you across... I'm sure you must be in a broader sense, these issues to do with Section 56 of the SIS Act?
Well, I'm aware of the issue, Senator, so I'll do my best.
Yeah, okay. How many times has APRA provided friend of the court services to superannuation funds that have sought to change their trust deeds?
Well, that's a very specific question, Senator, in terms of the numbers. What I can tell you is that there have been a number of court cases, 15 I'm aware of.
15?
Well, 15 in total that I'm aware of, state court cases. I would have to come back to you on how many of those we acted as a friend of the court in.
Okay. And what exactly did APRA do when these funds were changing their trust deeds? Or seeking to change it, sorry, I should be accurate, seeking to change their trust deeds so that they could pass on future regulatory fines to their members?
So my understanding of the broad sequence, Senator, is that there were amendments to section 56 and 57
Yes.
in 2020. So this is 4 years ago. Start date was deferred a year to 2022. During that time, various funds explored the idea of charging a fee to set up a reserve and sought various state courts' views on whether they could do that. In terms of what APRA was doing, APRA...
Sorry, how many funds did it?
Well, I can't give you the number of funds.
18, did you say?
I didn't give a number.
You didn't give a number?
No. I said a number of funds. If you'd like a number, then we can see whether we have a number.
I thought you said 15 before. Did you not?
There were 15 cases that I'm aware of. 15 cases.
Well, 15 cases of funds seeking to change the trust deeds.
Yes, that I'm aware of. APRA formed a view. APRA asked itself the question whether the behaviour of the funds in seeking the amendments was consistent with the new provisions under the SIS Act, and came to the view that they were not inconsistent. During the... And by the way, that seems to also have been the view by 4 Supreme Courts in New South Wales, Victoria, Queensland and South Australia. As you pointed out at the beginning of your question, APRA played a role as a friend of the court, and my understanding is that involved providing the court with context, information, particularly around the operation of the BFID prudential policy that assisted the court, we believe, in forming its view.
And the view was that it wasn't inconsistent with the Commonwealth statute on superannuation. That was effectively what you put forward as a friend of the court, is it not?
That's my understanding, Senator.
Yeah.
Correct.
So effectively now, those judgments now have cascaded to a position where there are going to be large fines levied on major super funds, it is the members that will pay, not the shareholder organisations. So that was a very consequential period where those trust deeds were changed, and I guess that takes me to my next question, which is how big are the reserves which are currently held by the super funds as a result of being able to change their trust deeds and then collectively charge their members?
Are you talking in total, Senator, when you say how big?
What is the total value of the reserves now, which are held by the funds, which can be used to pay future fines?
Well, I don't have that figure in front of me, Senator.
Okay. Well,
if you would like us to take it on notice, I'm happy to take it on notice.
I think it's very relevant to the current debate, so I'd be grateful. What happens then, Mr. Lonsdale, if the reserves that have been built up by a super fund, could be CBUS, could be any fund, are not sufficient to meet the regulatory fine? So if they have, for example, a reserve of $5 million, but the federal court awards ASIC a $50 million fine for CBUS not paying their insurance policies, for example, what happens in that case?
So I want to be careful, Senator, that I'm not drawing parallels to live cases. It's very important.
I'm just giving you examples.
And you are raising, in a sense, a hypothetical issue. But if I can answer the question this way, one of the primary motivations, as I understood it, from the funds in seeking to raise fees to create a reserve was that the inability to pay a fine or a penalty could result in insolvency of the fund, which would be very detrimental to the members' best interests. And so I think that was the primary motivation behind the events of the creation of the reserves.
But that is on the basis that there was no effort to take the money from the shareholders. The organisations which own the funds have not made any contributions to these reserves. These reserves have been built up by the members of the funds through paying higher fees, hence the amount of public interest in it. So I guess my question is, what happens if the reserves are insufficient now? You say it's a hypothetical, but perhaps you could take on notice what might happen if the reserves are insufficient. And then I guess I'm interested in what APRA is doing to assess the adequacy of these reserves given the slew of cases which are before some of these funds.
Well, I think I've answered the first part of your question, but I'm happy to take the second part on notice, Senator.
Take it on notice, okay. Now, I know that the Chair wants me to stop, but I do have one last round of questions. So do you want me to stop or come back?
Is it a 5-minute job?
No, I think the answers are very efficient, so it could be.
So we'll do 3 5-minute blocks and then release the ACCC, release APRA and move to ACCC. And that'll be Senator Sheldon, Senator Bragg and Senator Rennick. Senator Sheldon.
Thanks very much, Chair. According to the Financial Review's coverage of the announcement on 29th of January this year, Macquarie says it hired Mr Byers because his deep connections were attractive to help navigate relationships with regulators. Has Mr Byers helped Macquarie Bank navigate its relationship with APRA?
Well, Mr Byers is a member of the bank-only board, so I would expect Mr Byers would be fulfilling his duties as a board member in the same way as any other board member would be.
Sorry, I'm just asking, it's a very specific question. Has Mr Byers helped Macquarie Bank navigate its relationship with APRA?
Senator, I have not dealt with Mr Byers.
Has APRA?
Well, APRA, just finish the thought. I've not dealt with Mr Byers.
But answer the question, yes.
I think
the thought is going with the answer. I have not dealt with Mr Byers in his current role as a bond on Macquarie. But we have a supervision team who does deal with Macquarie, and I'm aware that all the board members, including Mr Byers, are operating as board members, as you would expect.
So can you now be direct? I gave you time to answer the question the way you wanted to answer it. Now I'm asking a direct question, which I asked before. Has APRA, to your knowledge, dealing with Mr Byers? Not whether he's acting as a board member or as a chair or as any other role. I'm asking, Mr Byers, does he talk to APRA?
Well, I have answered the question, Senator. Mr Byers...
You have not answered it directly, thank you.
Mr Byers is a bank-only NED on Macquarie Bank. And we deal with Macquarie Bank, we deal with the management, we deal with
and Mr
board
Byers.
members.
I'm asking a simple question. And Mr Byers?
Well, Mr Byers is a member of the bank-only board of Macquarie Bank.
So you do deal with him. Thank you. 3 years ago, under Mr Byers, correct me if I'm wrong, I don't want to verbal you, so if I misrepresented what you just said to me, please correct me.
Senator, can I just stop you there? I've answered the question and you've sought to re-answer the question.
You have dealt with Mr Byers. I'm just a layperson. I'm just trying to understand your answer.
Good. And
you have dealt with Mr Byers.
Senator, my answer is...
That's APRA, has dealt with Mr Byers.
My answer is Mr Byers is on the bank-only board of Macquarie Bank, who we deal with.
Thank you. 3 years ago, under Mr Byers' watch, APRA took action against Macquarie Bank over multiple breaches of prudential and reporting standards, and some of those actions, including additional capital requirements, are still in effect. Mr Byers would be privy to confidential information about that enforcement action that Macquarie could find useful to know, wouldn't he?
So what's the question, Senator?
I'll repeat it very slowly.
That
3
would be
years ago,
helpful.
under Mr Byers' watch, APRA took action against Macquarie Bank over multiple breaches of prudential and reporting standards. You're aware of that?
I'm aware that APRA took action, yes.
And some of those actions, including additional capital requirements, are still in effect. You're aware of that?
I am aware of that,
Thank
Senator.
you. Mr Byers would be privy to confidential information, is that correct?
Well, Mr Byers was the chair of APRA. As the chair of APRA, he would have had access to information. Whether that's direct supervisory information is something I think different.
I'm asking about confidential information. He would have access to confidential information, wouldn't he?
Was chair of APRA, yes.
Thank you. And about that enforcement action that Macquarie could find useful to know, wouldn't he?
Well, you would have to ask Macquarie that, Senator.
Oh, no, I'm asking you. Would that information be useful for Macquarie Bank to know?
Well, it's not clear to me what information you're talking about.
Don't double guess what the next question I'm going to ask you. I'm asking you a simple, direct question right now.
But your question to me, Senator, as I understand it, is Mr Byers in possession of information, some information, you haven't specified what information, that may be useful to Macquarie?
Well, I'm not aware what information is confidential. You are.
Well, Macquarie's a regulated entity, Senator. If you're asking me, I don't know whether you are asking me this, if you're asking me, would Mr Byers, be aware of what good regulatory practice and prudential practice would look like? Yes, he would be.
And he'd be aware of enforcement arrangements and also the attitude of APRA, which would be confidential approaches to particular issues. So there'd be an insider's understanding of how APRA operates, wouldn't there?
Well, Mr Byers spent a good time of his career in APRA. I would expect that he would have a good understanding of how APRA operated.
Now, according to the Financial Review's coverage of the announcement of Ms Rowell, Deputy Chair, you joined the board of Australian Retirement Trust less than a year after leaving APRA. Is that correct?
I think that is correct, Senator.
So that's before the convention applies? You said a convention applies for 12 months.
Well, Senator, that's a convention that I have adopted since becoming chair of APRA.
Right.
And so...
An unenforceable convention, if we just want to be clear, it's an enforceable convention.
Well, it isn't enforceable because I have no tools to enforce it. But what I would say is we do look very carefully at conflicts, as I outlined. If we saw a conflict after a member had left, if we saw a conflict, or perhaps a member, I'm not sure whether this did happen, if a member joined, say, a regulated entity very close to leaving, it would be open to us to write to that entity and to the member and remind them of our conflict policy and remind them of the protection of information. And what I would say that's very important is when a member leaves or an employee leaves APRA, they remain covered by Section 56 of the secrecy provisions. And that's very important.
Last question.
The deputy chair is been within 12 months, which is that convention you think is you've suggested is appropriate. According to the Financial Review's coverage of the announcement of ART, said that Australian Retirement Trust said that Ms Rowell's regulatory experience ramps up ART's expertise in that area as a time when funds' operational resilience and investment governance was under growing scrutiny. So very similarly to Macquarie, there are regulatory entities saying how glad they are to get greater expertise in how the regulator, that is you, APRA, operates. Is that in any sense concerning? Any sense, in the broadest sense, let alone specific?
Well, Senator, I think I've explained that the information that a member or an employee may learn while working in APRA is protected by Section 56 and the policies that we have. Is there a benefit in having people who work in APRA work in regulated entities if conflicts are managed and the provisions that I mentioned before adhere to? Yes, absolutely, because we expect our regulated entities to act prudently. And if you've worked in APRA, you have a very good understanding of what that is. And you can import that way of thinking about risk into regulated entities.
If I had more time, I'd put more direct questions to you on a series of other matters, but I could just be very clear to you that PwC answered the very same questions in a similar way. I'm not challenging your answers at this point. I haven't got time. But I have deep concerns about how APRA is operating in its very general sense and operating specifically about how it operates its governance arrangements. I just also want to put on notice that there will be, do you have any view on whether superannuation should be used to fund house deposits? Does APRA believe it should have a role in determining what policy funds should or should not support? Does APRA believe it should have a role in determining whether or not funds should communicate or take public positions on policies? Does APRA believe it should have a role in educating members on matters of policy? Did you at any point discuss with any superannuation fund proposed expenditure on member education initiatives? And can you please produce notes on your meetings with super fund chairs and CEOs and whether APRA indicated a view or held a discussion on potential education initiatives run by superannuation funds? I'll put that on notice.
Senator, I'm very happy to take them on notice. I would just like to make a final comment on your final comment.
Please go ahead. With the Chair's indulgence.
We take our responsibilities as prudential regulators very seriously. I've talked at length, I think, about our code of conduct. I've talked at length about our values and what we expect of our people. If you have concerns, I'd very much like to hear them. But I can assure you that we're very serious about our business and, yes, stop
thanks.
There. And Ms Lonsdale,
thank you. Thank you, Senator.
We'll hear more
thank you, Senator Bragg. Senator Bragg.
Thanks very much. I just wanted to tie up a couple of things before we move on. So, in terms of the role of a chair of a super fund, and just going back to our discussion about the appointment of directors, so the funds are able to choose their own directors, are they not?
In the end, Senator, yes, they are. So depending on the specific operating model of the fund, so whether it's a for-profit or profit-for-member fund, the board has ultimate decision rights in terms of who its members are.
Okay. So your role here is to put each director through a fit and proper person test.
Well, we have a set of standards. Fit and proper is part of the standards. We expect the standard to be satisfied. But at the end of the day, you know, as I said before, we do not have the power to appoint or remove directors. That is up to the board.
So it's unclear to me how, in fact, this fit and proper person test works. I've listened to you carefully about how you have explained the licence conditions you've placed on one particular fund at the moment. And you've explained, I think, that verbally in you, that you are putting those persons through a fit and proper person test. Is that right?
Correct. They are being examined by an independent party to make sure that they fit the requirements under 510.
Okay, so this is additional vetting.
This is additional vetting in the sense that we have a licence condition that requires it and an independent party doing it.
Okay, that's very helpful to understand that. So when you look at these people, and you make this assessment, I mean, do you take into account points in their past? For example, if they have chaired the worst performing super fund in the country, is that a factor?
So the key factors, just in general, so with 520 on fit and proper looks at competence, at character, at diligence, at honesty, integrity, judgment, whether they're qualified for the job under the APRA Act, and particularly on conflicts. If there is a conflict, sometimes there might be a conflict that is not a material one. So there are a whole range of factors, and we would expect that to be done regularly.
Does their prior work experience come into the picture?
Well, Senator, I would have thought that would have fitted under the ability to do the job.
Okay. I would imagine so. Just finally, and thank you for going over time with us tonight, I just wanted to ask you about what I thought was an unusual interaction.
Senator, are you moving off governance now, or is this...
This is my last question. It's still about governance.
Okay.
Is that okay?
Yeah, I've just got one general point to make on governance, but you go.
Okay. We had a hearing with the CEO of Cbus last week, and in that hearing I asked the Chief Executive about the commitment of $500 million of the members' money by the chair of the Cbus Fund in relation to the Housing Australia Future Fund. And the CEO said, quote, "I wasn't involved in that interaction," end quote. So I'm wondering from a governance point of view whether you would expect that the Chief Executive would be involved in committing members' money to major projects or to major investments.
Well, it's quite a specific example,
Well,
Senator.
it's a public example on the record.
Yeah, I mean, what I would say, I'd answer it this way, that we would expect at all times funds to be operating in the members' best interests. And where we do not think that is the case, we're on the public record. There are lots of examples of it where we take action.
So can you take action against a chief executive? Or is it only the directors in which you have jurisdiction under the governance prudential standards?
So we would take action against the fund, but there are new provisions coming in, for example, the FAR, that enable civil penalties, for example.
So as it stands, you wouldn't be able to sanction a person who wasn't on the board?
Well, I think we've got to come back. That's very specific, Senator. I'm happy to come back to you. Take that on notice.
Well, good, thank you.
Could I just make one general point? Sorry, Chair, because we've had a lot of questions on governance. Our corporate plan flags that we will be reopening the governance standards. So we've got 50 standards. This is quite an old one. We'll be reopening, issuing a discussion paper that will look at issues around fit and proper, around capability, around tenure, around a whole range of issues. So I just want to flag that that will be happening.
Thank you. I'll just go now to Senator Rennick.
Hi, how are you going?
Good evening.
Sorry, I'm going to keep talking about governance, but it may be a question of policy, so I'm happy for Senator Ayres, Minister Ayres, to answer it. Why...
I'm just about to put a cough lolly in my mouth, but I might wait.
Okay, all right. Well, I'm
Excellent
sure...
contribution, Minister. Thank
Yes.
Always happy to help.
Shouldn't, and I'm happy to get both points of view here, but shouldn't super funds actually allow members to elect their board? I mean, wouldn't that be a much more democratic process?
Well, that sounds like a matter of policy, and it's not something that that the government's contemplating
Don't you think they should contemplate it, given that the members... So do you think... Let me put another question. Put it another way. Shouldn't the members have a say in who manages their money?
These funds, I assume you're referring to the industry funds.
No, I'm actually referring to both funds. I'm not taking sides here. I've got...
The other funds are private funds and they don't have those sorts of arrangements. They are for-profit funds.
But they're still appointed as well, aren't they?
The industry funds have been very successful. It's a very successful model. The government's obviously...
That's not the question.
The government's obviously, alive to future reforms to support the growth of superannuation. But you'd have to say all these decades down the track from when unions and employers in these industries founded industry superannuation, many of them after very difficult industrial struggles to form these funds, to establish them in the award system. And through the enterprise bargaining system, over that period, it has been a very, very successful model in the national interest and in the interest of
that's a matter of opinion.
Workers who now have retirement income that they otherwise would not have had.
A lot of people don't actually. The median balance for women aged 60 to 64 is 158,000. So I wouldn't consider that a figure to retire.
If you've got questions about superannuation policy, APRA is probably not the place to ask it.
Well, they oversee superannuation funds. And don't avoid the question.
Well, the prudential regulation of superannuation funds, I'm sure Mr Lonsdale will be delighted to answer your questions.
Well, and that involves governance.
Policy questions.
And part of the problem here is the poor governance that we've just seen in the last 2 weeks. It's been disclosed that CBUS Super haven't been paying out people in a timely manner, and other super funds.
That's why we have regulation as these problems emerge.
Well, clearly we haven't had good enough regulation, because I've spoken to people directly who are dealing with the grief of losing a loved one, and then the super fund's making it very difficult for these people to access their money to help pay for the bills.
Well, as I've indicated, that's why we have a prudential regulation arrangements, and that's why we have the other regulation arrangements that engage with superannuation. And when the regulator discovers an issue that they need to engage with, that's what they do.
And, OK, well, I'll leave it as a comment that I think the members should be able to have a vote. I mean, we vote in democracy. We should be voting in the way our capital is actually allocated. Should super funds also seek direct proxies before they get to vote in AGMs? So companies actually have AGMs where they get to appoint the board, but yet super funds who aren't elected, or super boards who aren't elected, then go and vote in companies' AGMs without seeking the intentions of their members. Do you think that's democratic? Well, again,
Senator, I think you've arrived probably in the wrong place for that.
No, I think question. I'm in the right place, actually.
In terms of the agenda, you're very welcome here. But in terms of these questions about the regulation environment, if you ask me what I think about that, I think superannuation boards have got to make decisions about all sorts of questions, including making judgments about their ownership of businesses or parts of businesses, and they've got to make those decisions wisely.
Last question.
Yep. People weren't actually given a choice. I'll leave this comment because I actually will have one other question. People weren't actually given a choice to actually if they ever wanted to hand over 12% of their wages. But I'll leave that comment. But Mr Lonsdale, can I just ask you a quick question, and it's more a general state. Do you know why banks don't offer 25-year loans here in Australia?
I
know other countries do it.
So I think the short answer is we're not regulating the product that they sell. That is a commercial decision for banks. We're regulating around the risk.
No worries. I just thought I'd ask.
Thank you very much, Senator Rennick. Thank you, Mr Lonsdale. Thank you, Ms Beverly Smith. That's all our questions. You go with our thanks. Thank you.
Thank you.
The committee now welcomes representatives of the ACCC. We welcome Ms Cascott-Leeb to the table and members of her team. And I let committee members know that we are 35 minutes behind on our spillover, so we'll be very efficient in our questioning. And Ms Cascott-Leeb, are you happy to proceed straight to questions, or was there a statement that you wish to make? You are welcome to do so.
Thank you. I will do it promptly. Good evening.
Oh, I see. Sorry, we have it.
Yes.
We will table it, and please go ahead.
Thank you. Good evening, Chair, and also to Senators. I do like to start by acknowledging the Ngunnawal people, the traditional owners and custodians of the land on which this wonderful house sits. I pay my respects to them, their culture, and elders past and present. I and my colleagues in the senior executive management team of the ACCC are pleased to be here. We are here both in person and virtually. With rising cost of living front of mind for many Australians, the ACCC is maintaining a strong focus on competition and consumer protection and enforcement in these areas, particularly in respect of essential products and services important to household budgets. Last month, the ACCC instituted proceedings against Optus for allegedly engaging in unconscionable conduct when selling telecommunications goods and services to hundreds of vulnerable consumers, products we allege they often didn't need or want. Since we last appeared before you, we've also instituted proceedings against Coles and Woolworths. We allege that each of them breached the Australian consumer law by making misleading claims when the discounts were in fact illusory. We are not only instituting new proceedings but have also seen results from previous enforcement actions. In October, the Federal Court ordered a $100 million penalty against Qantas for misleading consumers by offering and selling tickets for flights it had already decided to cancel, which is in addition to $20 million in remediation to customers. September, Energy Australia was ordered to pay $14 million for making misleading statements about electricity prices and for breaching the electricity retail code by failing to state the lowest possible price in their pricing communications. These cases are the result of the careful application of our enforcement priorities and triaging systems to the hundreds of thousands of contacts and intelligence data points we collect each year. Our model prioritises cases with the greatest harm or potential for harm and focuses upon the priorities that we have set, which each year are informed by this information and intelligence that we receive. We have recently received, under an announcement from the Treasurer, $30 million over 3.5 years in additional funding to go towards investigation and enforcement relating to the supermarket and retail sector, which will enable us to escalate a range of investigations in this sector, including in relation to potential misleading pricing claims or practices, misleading claims about delivery timeframes and costs, and businesses misrepresenting consumers' rights and guarantees under the Australian consumer law. We also have a important role in enforcing competition and cartel cases, which is an enduring priority for the ACCC. Over this past period, we received and went into consolidated revenue, total fines and penalties in our competition enforcement program exceeding $100 million, including cases in the waste services industry, flat steel products, pricing industries, and that is the highest total we've ever achieved in competition cases in a financial year. In mergers, I anticipate we will get some questions in respect to the Merger Law Reform Bill, which is making its way through and still under consideration in this House Our inquiry work is also relevant to the cost of living. We are currently conducting public hearings involving senior executives of Aldi, Coles, Metcash, Woolworths and representatives of consumers and suppliers. These hearings will help the ACCC gain a more complete understanding of the key issues in the retail grocery sector and its associated supply chains before providing the final report to the Treasurer. Our monitoring roles more broadly in sectors such as telecommunications, retail, electricity and aviation also report on areas that are key drivers of household costs. I expect we will cover the National Anti-Scam Centre, so I won't address that in these remarks. I do point out that each of these are important contributions to consumer protection and the promotion of competition, each of which are important in the context of cost of living pressures, and I thank the committee for the opportunity to provide this statement, and we look forward to your questions.
Thank you very much, Ms Cascott-Lieb. We'll go by agreement of the committee in 5-minute blocks, and I'll go so that we can release you to you, Senator Colbeck. If you're ready to go.
Yep. Chair. I want to go to some questions with respect to what I regard as misuse of market power down the supply chain, where wholesalers are being asked to sign an updated supplier agreement with a business, Akubra, and it starts in a pretty interesting way. So the background to all this is that Akubra say they have conducted a review of their operations. The review identified the need for us to make some improvements. These improvements include streamlining our wholesaler network. So the first thing in this whole thing is a threat. Some of you guys are for the chop. And so agree with our new conditions or you get the chop. The next point is that we're approaching our online presence more strategically to better manage our brand and deepen our connection with our customers. As part of this, we will be taking control of the e-commerce distribution of our products. In other words, we're stealing your online business. I don't think that's an acceptable way to operate. You will no longer be permitted to sell our products online. Now, these are, well, the business that I'm talking to is not a huge business. They've got a local area network where they've got good and loyal customers, but they sell online. But they're being told by Akubra under threat of, what's the term? Streamlining our wholesaler network, that they need to sign up to this new agreement. The agreement goes on to say that they must, under promotion, marketing, advertising and sales, promote in a manner which, to the extent reasonably possible, promotes and supports the image of Akubra and the goods in the market, and not do anything that or which could adversely affect the value, reputation, brand image of Akubra. In other words, they're telling them what price they have to sell the product at. So almost price fixing as well. And of course, then they're saying you must not use the intellectual property in any paid advertising marketing campaigns as opposed to organic use on your social media. So they're effectively stealing their online market and saying that they can't advertise anything other than the recommended retail price. Now, if I'm a small operator operating in a regional town, Victoria, New South Wales, somewhere like that, and I want to sell Akubra hats at a lower margin than Akubra's recommended retail price, say, I know I'm happy with an $80 margin on a hat instead of a $90 or $100 margin, so I'll sell it $20 cheaper. I'm not allowed to advertise that fact by Akubra. Is that reasonable behaviour by Akubra?
So I think it best that I talk about the nature of conduct you're describing rather than necessarily a particular company, because I would not want to appear to be forming a view.
So can I say I've been approached by a small operator, scared witless that they don't want to be identified, because if they're identified, they become part of the streamlining of the business. So I mean, they're very interested to know if Akubra can steal their online market. They really do want to understand.
So let me run through the various aspects that have been referenced, and also for the constituent who has raised this with you, also can approach us in a confidential manner to report concerns. Okay. So firstly I would say that.
Could I provide information to you confidentially on their behalf?
Yes, you can. Absolutely, you can. And you can write to us and we will reply. But I'll just quickly address a number of points. Whether or not there would be a question of misuse of market power will depend upon are there other constraints upon Akubra such that they are operating constrained by other manufacturers, and it may not be the most relevant part of our Act to look to. However, if they are supplying to a distributor, if a company is supplying to a distributor and sets a minimum resale price, that can be a contravention of the resale price maintenance prohibition, because our Act does wish to see competition in price at the retail level. So that could be a question that should be looked at. In addition, there would be questions under the consumer law as to whether these are unfair trading contract terms, particularly to change terms unilaterally if there is a large company to a small business with an imbalance of bargaining power. Then we can also have an unfair contract term. We would also note one of the areas of legal change that the ACCC has been very strongly supportive of is the introduction of an unfair trading practices prohibition, and that would be the sort of prohibition that would allow a general review of an overall course of conduct without needing to find specific unfair contract terms. So there are a range of questions that could be considered, and we would be happy to receive a letter in relation to this.
So, I mean, clearly been a trading relationship over a period of time here. Effectively coming in and saying, we're taking your online market, I mean, how does that fit within the terms of fair trade? That's what's happening here. Effectively at threat of no longer having access to the product.
Yes. Under the unfair contract terms, there are provisions that specifically do look to the reasonableness of terms. Are they being changed unilaterally? Do they set unreasonable periods? Do they impose a burden, particularly in circumstances for small businesses engaging with larger businesses with an imbalance of bargaining power? We also do have, under the current law, prohibitions of unconscionable conduct in the dealings of large companies with small businesses. We would have an even more effective power to address such questions in the broad with an unfair trading practices prohibition, but we have current powers.
Are you able to conclude with this question, Senator Colbeck, or shall I share the call and come back?
I'll finish with this question, and thank you for your evidence. What about the pricing element? If you're not allowed to, if suppliers saying you can't advertise our product to your customers, but if you do, you have to advertise it not at your price.
there is certainly a prohibition on what's called resale price maintenance, which is stipulating a mandatory minimum price, because distributors are under our law to be free to set a price which is lower, to set what the price they think is competitive. So that can certainly be considered or investigated in that context.
So as a distributor, my margin is my business, and I can't be constrained in setting what I think my margin for my business is.
So interestingly, a manufacturer can set, apart from a recommended retail price, they can set a maximum resale price. However, they cannot set a minimum resale price.
Okay. Thank you. Thank you for evidence. Thank you, Chair.
Thank you. Senator Smith.
Thank you very much, and thank you for your participation tonight. I might just start with a constituent-related matter, if I may. In July, I wrote to the ACCC on behalf of a variety of constituents raising concerns with the craveable brand franchisees, and I was just hoping I might be able to get an update on that, and then I've got some high-level questions in regards to a related matter.
So I am aware of that. It has certainly been subject to investigation. I will also pass to the head of our Consumer and Fair Trading Enforcement team, Rami Gress.
So Rami Gress, Executive General Manager, Consumer and Fair Trading. Senator, so we are aware of the allegations, and we've received information from a number of parties, and we've sought information as well. So we're at the beginning stage of an investigation. Our investigations, as you'd appreciate, are confidential, and so I'm not really at liberty to share too much detail other than to say that we are engaged in that matter. It's also worth noting that these matters can be quite complex and involve quite a reasonably lengthy period of time of investigation, and so it's just worth being aware that it may not result in a public outcome in the near future.
What steps does the ACCC take to get to the point of initiating an investigation? And I'm right to assume that an investigation has formally commenced?
So it has, that's correct. We don't normally make our investigations public. However, if they happen to be in the public domain, as this one is, then there is no bar to us referring to it. Essentially, when matters come to our attention, fall within our priorities, we examine them, we look at I suppose, conduct that we consider to be serious and significant, and there's an evidentiary base to proceed, then we continue to investigate.
So this matter, I did see it in the Chair's opening remarks, this matter has met the requirements to be considered a priority investigation?
That's correct. Insofar as we have as an enduring priority conduct affecting small business, and clearly that meets that description.
So in the Chair's opening statement it says, contacts from consumers and small businesses are also important contributors to our annual setting of our compliance and enforcement priorities for the coming year. So this particular matter falls into that compliance and enforcement priorities that the ACCC has currently identified?
That's correct.
And then finally, how does the ACCC keep interested parties abreast of the investigation, and at what point do interested parties learn about further legal action or initiatives that the ACCC might take? In this case, on behalf of the franchisees?
So perhaps I could just address that last comment. It's not action on behalf of the franchisee,
true, yep.
so it's and it's also worth noting that sometimes the franchisees' interests aren't necessarily the matters of the investigation. However, to your main question, it's often the case that interested parties may be persons with information that the ACCC will need to speak to, and so to that extent they will have engagement with the ACCC about the progress of the matter, at least from the point of view of their giving evidence. But as I think I said earlier, we don't normally keep parties informed about the progress of a matter while ever it's confidential. So it may be that if there are interested parties, they may have to wait until the matter becomes public, if it becomes public.
If it becomes public. Are you able to disclose to the committee how many representations you received or how many complaints you received in regards to craveable brands?
Yes, so we received 41.
Received 41.
Correct.
Okay, thank you very much for that. If I may, I might just turn to the matter of merger reform. The Chair will be pleased to know that one part of the parliamentary process was achieved today with its passage through the House of Representatives, but much of the commentary has focused on transparency around implementation.
Yes.
And the Senate Economics Committee report, while offering the Coalition's contributions, while offering support to the bill, did, echo some of the remarks that have been made by the Business Council and others about improved transparency and a focus on the implementation regime. And in the ACCC's own document, which I'll find in a moment, in its own document, the Statement of Goals for Merger Reform Implementation, it specifically identifies the Performance Consultative Committee.
Yes.
And I was hoping you might give us an up-to-date explanation, up-to-date as of today, given we've had the Senate Committee report now. What is the suite of things the ACCC is going to do to meet some of that stakeholder interest in transparency, reporting and implementation?
Yes, thank you very much, Senator. And we are very pleased to see the passage through the House. I have also reviewed the report from the members of the Senate Committee. When we look at and we are aware of the strong interest in transparency measures. So I will just outline them, starting with the broadest, and the broadest will be the register. Because the register will hold on it both the initial information as to the parties and the description of the transaction. It will then hold on it an update as at when and if, either within the first 15 to 20 days in a fast, streamlined process. There is an approval that will then, within 24 hours, go on to the register with the reasoning. If, however, by the end of the 30-day period, it moves to the next phase, there will then be an explanation why it's moving to phase 2. Then, if there's a notice of competition concerns, that will also go on the register, and the final decision with the reasoning and grounds will go on the register. So we will move from a situation currently that 90% of notifications are cleared confidentially in pre-assessment, again within maximum 1 month, but are wholly confidential, to a position in which there is a significant increase in transparency available publicly on the register. And directly to the parties, but publicly on the register. In addition to that breadth of transparency, We are in the process, in fact in the coming week, of writing to members of our reconstituted ACCC Performance Consultative Committee. The members will include small business and large business. It will include particular sectors which have close interest in the mergers and concerns and were strongly supportive of the bill, including the National Farmers Federation as well as small business. We'll include the BCA, we'll include consumer representatives, we'll have Treasury Observer as well. And we intend to have the first meeting by March next year, and then regular meetings during the year. And in that committee, we will set an agenda that reflects the issues that the stakeholders want to raise with the ACCC. We anticipate at that point we will be in consultation on our draft guidelines.
Right, okay,
so we will use it as a basis to receive input. But that is still in the preparatory phase. We will commence to get, on a voluntary basis, notifications from 1 July and mandatory ones from January. And very rapidly, the Register will deliver it in response to the BCA's request, which was endorsed by the Coalition in the committee report. We are also going to provide quarterly publication of the performance indicators on the merger timelines, and particularly the use of Section 155 notices. As I said in the hearing before the committee, that we would adopt and respond to that as well. We will also annually be reporting overall on the progress. So it will be a very significant shift from quite a degree of confidentiality to a very transparent system.
So will the Performance Consultative Committee be agile enough as a consultative forum?
We consider so. We intend to send also documents in advance and to also give capacity for the committee to also give us input on what matters that they are looking for the purposes of consideration. I have received at least from various business representatives an interest and a keenness to participate. Right. So I do think they can see that.
Am I right to assume it's like it's a committee of practitioners, or is it more of a policy committee in terms of the membership?
Thank you. It will be a mixture of stakeholders, including business representatives and those chosen, including the Australian Tech Council, as well as the BCA, as well as ACCI, and as well as COSBOA. But in addition, we will have legal practitioners as well.
And is there any
I think you can't hear me.
I think you'll like the question, Chair. Just one very, very brief one. Will the minutes of those consultative committee meetings be publicly available?
We were intending to have the discussions in a Chatham House fashion to encourage people to feel free to speak, but that we would then provide to the participants a summary of what has been discussed, and if they are then comfortable, that we would then produce it. Yes, we would then publish it.
Senator Roberts.
Thank you, Chair. Thank you for appearing tonight. I'm pleased to hear you say, and I've read your opening statement, the cost of living is important. It impacts, competition impacts cost of living. I'd like to understand a little bit about our motor vehicle industry and your involvement in it, because there seems to be some systematic levels of lemon cars being sold by some manufacturers. If they feel that there are no consequences for selling dodgy products, won't that have a significant impact on competition in the motor vehicle industry?
This is an important issue that the ACCC and the state and territory consumer protection regulators are very engaged in. There is, in terms of a range of new vehicles, they are each subject to consumer guarantees, so that there is an underpinning of fitness for purpose and that they meet the qualities and specifications on which they've been sold. The ACCC is seeking, and the government has announced, reforms to the law such that if there are contraventions of a guarantee, including on a motor vehicle, that the ACCC can take action not solely to require giving a consumer the remedy, which currently is an action that can be taken.
So you can do that, ACCC can do that?
We can. However, we find that, and consumers find it very difficult to do so, we find it is a poor way to get actual compliance. What the law reform proposes is that will actually be a breach of our Act, and where you see repeated indications of this, that we can seek significant penalties as well as consumer remediation, because it is reported to us and reported to state and territory regulators that this is a problem, particularly a problem for lower income families and consumers, and it is a problem that we seek with the states and territories to take action on, but being able to take action for serious and systemic breach and get significant penalties will be the best deterrence. I will just ask if...
So in other words, you'll strengthen your provisions, add provisions to it?
Yes, that is what we're seeking.
Specifically because you're aware that there's a systemic, among some manufacturers, systemic quality issues.
Exactly. But I will just see if Mr Gress wants to add.
I'd just add, Senator, that we've also taken over the years quite a number of actions for those types of systemic issues against a number of car manufacturers, Ford, Mazda, just to name two. They are very intensive exercises, very resource intensive. But as the Chair just pointed out, the ability to be able to penalise for failure to abide by the consumer guarantees will be a very important reform.
Thank you. That was a comprehensive answer. Thank you very much. Now, a car is the third biggest investment cost of a person's life, usually. Housing would be number two. Government is by far and away the biggest cost during a person's life. So let's move on to housing. A house, are you doing any work on the property market in terms of land development? Some developers are acting like a cartel and keeping land locked away in the middle of a housing crisis, waiting for the demand to get even bigger to raise their price. What are you doing in this space?
So our exposure will either arise in mergers, and we did review, or was voluntarily notified to us, a merger in terms of the function of master plan planned communities. So it was an acquisition that brought together assets of Lend-Lease was selling some assets which went to Superannuation. And in relation to the Illawarra area, where we considered that there would be too much concentration post the transaction, we required a divestiture in order to retain continuing competition. So one exposure we have to this, and an important role that we have, is merger control, and with the reforms, if passed by this House, we will have much more visibility in relation to the transactions we need to look at. If we were to become aware of cartel conduct or reports of anti-competitive conduct, that would absolutely be within our enforcement remit against anti-competitive conduct. We do not have an overall supervisory function in relation to housing. It arises in relation to maintaining and promoting competition.
So you're not are you?
I'll come back to you, Senator Roberts.
If I ask this simple question, that'll be me finished.
The committee advises that we release the Productivity Commission, and you go with our thanks. Thank you, Senator Roberts.
Thank you. Are you aware of any developers that are withholding land from the market to bump up prices?
I don't believe we are aware of that, no, Senator.
Thank you, Chair. That's the end of my questions.
Thank you, Senator Roberts. Senator Smith.
Thanks very much. I do want to turn now to the ACCC's National Anti-Scam Centre. Can you tell the committee how much money has been provided to the ACCC for the National Anti-Scam Centre thus far?
Let me just make sure that we get the complete answer on that. And also you can see on screen Sarah Proudfoot, who is the General Manager and Head of our National Anti-Scam Centre. But one moment, and I think our CEO, Mr Gregson, will give that answer.
Senator Scott Gregson, Chief Executive Officer of the ACCC. We've received over time different amounts, but in relation to the National Anti-Scam Centre, in this financial year we received $9.6 million to assist with a campaign, and that continues in out years at lower amounts. We've also received underlying funding to support the NASC. That is in total $43 million over 3 years, 11 million in last year, 16.4 in this year, and 15.6 in the following year.
And a key part of that is a technology cost as well, to establish the infrastructure to enable automatic sharing of data.
In fact, Senator, if I could correct that, the numbers I just gave for those last three were for that underlying IT. The base funding for the NASC has been over 2 years, so for 23-24 at 7.1 and 24-25 at 6.9.
So the technology build is the 11 million plus the 16.4 million plus the 15.6 million, so approximately 43 million.
Precisely, Senator.
Yep, great. And then there is a $9.6 million contribution, which is a campaign contribution.
That's right, Senator.
Yep. And then finally, there has been a $7.1 million contribution and a $6.9 million contribution, which is for the...
Effectively the staffing of the NASC at the ACCC, Senator, and in total that's the 14 for that component.
Okay, thanks very much. Does the National Anti-Scam Centre publish reports and updates on scams data and trends?
We have, and we do. What I thought would be useful would be to address, because we've quite a breadth of sharing of scam reports. We do some automatic and regular, some then periodic, and then others that are ad hoc. So I just want to quickly cover that. Looking at automated, every 2 hours we send scam suspect BSB and account numbers from ScamWatch reports to the Australian Financial Crimes Exchange for provision to the relevant financial institution. This is all where the party reporting has consented for the information to be provided. The Australian Financial Crimes Exchange then puts an email compilation together and sends that information weekly to the banks. MoneyGram and Western Union both receive scams weekly reports about scams citing the payment method where the reporter has consented for the sharing. So that's in the financial services sector. In telecommunications, every week all suspect phone numbers reported in alleged text or phone call scams are provided to 11 telecommunication services providers and the ACMA. And the providers are all the usual telecommunications carriers and carriage service providers. With digital platforms every day, we send suspect URLs on the Meta platform and identify Meta where the reporter has consented to do so, and Gumtree receives reports weekly. We send investment scam reports to ASIC, and that is done daily via an application programming interface, an API, so that ASIC can assess and take down them. And then monthly, every month we report to ACMA on phone porting, SIM swapping, every month to ASIC, every month to the NBN, an update on scams occurring on their platform. And ad hoc, we provide intelligence reports of trending scams and provide information on key suspect identifiers to the relevant bodies. It includes to WhatsApp phone numbers that are problematic, Google, Meta, and we provide that data and expect action to be taken. In addition, we have on our ScamWatch website, in essence, a dashboard that everyone can access and set the period of time. I find out what is the number of reports, what is the number of losses, and what are the top 3 areas of type of scams: investment scams, romance scams, and the channel that it has come to people. So we have built a very extensive set of data dissemination programs and processes, and we are continuing to work on them to move as many as possible to be automated.
So, turning to the publication of reports, the ACCC website says that it publishes quarterly updates, and there's a March 2024 update, there's a November 2023 update, and there's a May 2024 update. So I'm just curious to know, where are the other quarterly updates?
The most recent one has been delayed, though we are on track to produce it next week. And the reason it was delayed is that when we get ScamWatch data, the Australian Financial Crimes Exchange gets data from banks. Report Cyber gets data from the law enforcement agencies. We gather the data together. One of the aspects that requires care is that victims or family members of victims can report to multiple places, and we are trying to deduplicate that data for an overall global reporting point of view to give the community, the Parliament, the government, a robust sense of what the actual data is, particularly as we're trying to track how the numbers are changing over time as we're taking initiatives to seek to disrupt and prevent. And on this occasion, there were some inaccuracies in data that we received from one of the contributing bodies, and we had to work to address that.
So the report that is the quarterly report that will go up on the website next week is the...
To 30 June.
To 30 June.
Yes.
And it's not been necessary to delay previous quarterly updates as a result of any inaccuracies in the data?
Let me test that. Go to Sarah Proudfoot to get a precise answer on that question.
Good evening, Senator. Sarah Proudfoot, Executive General Manager of the National Anti-Scam Centre. We have sought to publish a report every quarter since the National Anti-Scam Centre was created on the 1st of July 2023. So this Q4, as we're referring to it, will round out the set. I can't tell you the exact timing. I know that as we've developed more partnerships and been getting more data in, the data sets that we're working with have become more complex. We generally seek to have a report out within 2 months of the end of the quarter. So obviously this one's a little bit behind that, but we are very pleased to be getting it out and creating that first year of the National Anti-Scam Centre in a full set of reports.
So the 30 June quarterly report gets released next week?
Yes.
So when's the next scheduled quarterly report after the 30th of June, and will that be published on time?
We are actually in a process of considering whether we should move to less regular reporting in that set of reporting. And the reason we are considering that is because we have found that the process to ensure that the data is robust and not duplicated is complex, and we are working with the other parties who gather the data in order to seek to build up a better understanding amongst each of us about the rigour with which the separate data sets are put together. And once we have that, we will be able to then determine what is the right time frame.
So the delay in the 30 June report is because of inaccuracies.
Yes.
So what is the complexity that now exists that didn't exist to allow for the quarterly reporting of previous reports? What has changed?
Sarah?
Senator, if I may, I think it's, I would use anomaly rather than inaccuracy to describe what came through in the data that was of concern for this Q4 report. One of the challenges we have, and one of the areas that the NASC is working on, is trying to get greater consistency in terms of how scams and scam losses are reported. And that includes details like whether you're using the date that the loss was incurred or the date that the loss was reported. And those can be different, and they can mean different things that get reported in different ways across the quarters. And so you may end up missing some in one quarter that then appears in the next, or people may, we see on ScamWatch, retract reports that they've made because they've discovered it wasn't a scam or they don't consider it a scam. And so what we're finding as we're getting more reports, which on the one hand is not a positive thing because it means people are still being scammed, but on the other it means they're sharing the information so that we can use that as intelligence and try and break down the scammers and disrupt them. It has just added a level of complexity to the work that we're doing, and as Ms Scott-Lee mentioned, we've already been thinking about concerns we have around duplication and what that meant. And so we really are keen to do what we can to get a really clear data set that we can then use as a baseline to assess the ongoing success of the NASC and the work that's being done across the scams ecosystem to fight scams.
Has the ACCC found it necessary to keep government abreast of its, my words, but its sort of changed approach?
So the Minister does from time to time participate in the meetings of the advisory board, which include industry sector participants as well, and aspects that relate to these challenges and our work with other participants. So we have on that advisory board ACAN, the AFP, AUSPaynet, Blockchain Australia, Communications Alliance, consumer bodies, and so we are seeking to ensure at an operational level that the participants who we receive data from and also across government, that there is an understanding of this process that we're seeking to engage in to improve the data and the robustness of the data.
So the requirement, so the recognition that the data needed to be more robust, was that identified by the ACCC and reported to the advisory board, or was that identified by the advisory board and shared with the ACCC, and the ACCC took that on and followed it up and has come with an alternative regime for the publication of data?
I believe we have seen these problems emerging. I'll check with Ms Proudfoot if we should also add to that answer.
No, that's correct, Ms Cascotlo, particularly in relation to this incident, but I think it's reasonable to say that there's a high level of interest within the advisory board and beyond in the scams data presentation and how people can see that and how it's presented.
On notice, could you just let me know how many advisory boards there have been over the last...
How many meetings?
How many meetings since it was created, and how many of those meetings the Minister has attended? Is there any interrelationship between the government's preparation of the scam legislation framework and the decision to change the regime around the publication of the quarterly updates?
None.
None? So just to recap, the 30 June quarterly update will be published next week. Then the one after that may not be published at all, or that is subject to this more robust, that is, the publication of that quarterly report is subject to this discussion about what is the best way to present the data?
It's subject to the discussion. And just quickly on, because we are providing, in a sense, raw data as quickly as we can in the way I started, we're also providing the ACCC Scam Watch data very regularly. Each month we're updating it on the Scam Watch website. We know that what is really looked to with this report is the combination of all the sources of data. We can be much quicker with our own Scam Watch data because we understand it. It's done according to our template.
Yeah.
But we know this report, Senator, you're looking to, and each of the key participants in the sector are looking to in order to rely upon it as setting trends. And we have felt we need to devote some care and thought to get that right. Though we are at the same time progressing a lot of data reporting.
Okay. We've got Housing Australia and ABS, and we've got 55 minutes left.
One more 5-minute block?
I think that's fine. Yep, Senator Smith.
Briefly on one matter before I go to the Optus matter, if I can. Am I correct to assume that the PEXA Simply matter has been a matter that the ACCC has been alert to, and has it done any serious work in trying to respond to the anti-competitive issues that Simply particularly has been making to government, to the Treasury, to the Competition Task Force, and I understand to the ACCC? And do you have a suggested pathway in terms of how this impasse might be corrected?
We are alert. We are alert to it. We have, in an overview sense, we do consider that this is an example of a very important policy to facilitate e-conveyancing on a national basis, but a set of decisions by state and territory governments to put together what had been government sole providers into a privatised monopoly without a sufficiently clear and certain regulatory framework. And that is one which required interoperability as a condition, in effect, of the transfer of that ownership. And the regulator that is established, ARNEC, so the state and territory registries, also have not had the sort of background in an enforcement skill and craft sense. So there we can see challenges in that framework, and it has been a key matter that we have engaged with the National Competition Review, and we know that this is being considered carefully at the task force, that it is very important that before there is a privatisation that confers a private new monopoly, that it is very important to have sufficient regulatory framework.
So this policy matter, because the National Competition Task Force has its National Competition Review process and its consultation matter. So has the matter at a policy level been discussed with the National Competition Task Force, or has the PEXA versus Simply matter been discussed by yourself and the Competition Task Force?
So both. We are also aware that there is consideration of enhanced regulatory requirements sitting with ARNEC. I can see that Ms McDonald, who's the head of our competition enforcement team, is on the screen, and I will see if Ms McDonald would like to add to that.
Thank you, Chair. Melinda McDonald, Executive General Manager for Competition Division. Senator, thank you for the question. I thought it might be helpful for you to note that during the interoperability reform process, some concerns have been raised with the ACCC that PEXA may be engaging in anti-competitive conduct. Now, naturally, wherever such concerns of that kind are raised, we consider them carefully. But where our work is ongoing, it's really not appropriate to comment further on that particular matter at this time.
Okay, except it has been a matter that's been going on for a very long time. Parties associated with Simply and Simply itself are hugely frustrated. During this Senate estimates process a few weeks ago, Treasury officials did say that if the RNEC was to refer the matter to the National Competition Task Force, it would, look at the matter more seriously than it has looked at the matter thus far. So from my point of view, is the ACCC investigating the matter, or is the ACCC just aware of the matter? Has the ACCC identified a pathway that might be suitable to have this very obvious competition matter addressed?
Senator, I think the most appropriate way for me to respond to that question is to say that we are still in the process of assessing those concerns, and I wouldn't characterise it as an in-depth investigation at this stage, but naturally the concerns warrant further consideration.
Okay, so how does that consideration get considered? How does the matter get considered by the ACCC? At a high level, can you, provide me with some information about what are the steps in that? Do you have all the information you currently need, or will you be seeking additional information?
I think it's fair for me to say, Senator, that we're still in the process of gathering relevant information in order to complete the assessment.
Great. And when the assessment is completed, what happens with the assessment? Does it go to PEXA? Does it go to Simply? Do you invite PEXA and Simply into the ACCC? Does it get sent to a relevant minister? Does it get sent to the Treasury? I'm just curious to know, once the assessment is done, how does that get shared, and how does that become publicly known, the ACCC's assessed view of the issue?
Well, I'm speaking to you, Senator, in respect of the work that we do in the Enforcement Division of the ACCC. So in terms of progressing an investigation, we gather all relevant information to make an objective assessment of the alleged conduct in respect of the provisions of the Competition and Consumer Act. As to how an investigation progresses and whether it progresses to a stage at which it may become a public outcome or not, that then sort of depends on the facts and circumstances and what we uncover during the course of the investigation. It's probably not much more I can add to that at this point.
Look, I think it's fair to say it is like pulling teeth, there's no doubt about it, but I think we are ever so slowly making some progress. But thanks very much for your cooperation thus far, and we can explore it again in February next year.
Thank you, Senator Smith. That concludes the questions we have for the ACCC. Thank you, Ms Cass-Gottlieb and team, as always, for answering our questions. You go with our thanks. Thank you. The committee will now move to Housing Australia, and will take a brief suspension until they arrive at the table. And we welcome representatives from Housing Australia, and we welcome Mr Scott Langford and team. Welcome Mr Langford, and welcome to your first appearance before economics estimates in this role, but your second appearance in front of the Economics Committee in recent days. Yes. Do you have any opening remarks that you'd like to give?
I do, Chair. Thank you.
Thank you.
Well, thank you, Chair, Senators and colleagues. Acknowledge I've got some colleagues online as well. Thank you for the opportunity to address the committee. I'd like to briefly outline the contribution that Housing Australia has made to improving housing outcomes, and also briefly address the status of the first funding round of the Housing Australia Future Fund facility and the National Housing Accord facility. Housing Australia has two main streams of work. Firstly, we support the development of housing through various financing, investment and grant mechanisms by partnering with the private sector, community housing providers and all levels of government. To date, Housing Australia has, through the Affordable Housing Bond Aggregator, approved finance to support approximately 18,800 homes held by community housing providers, and provided funding approvals to unlock 11,700 homes through the National Housing Infrastructure Facility. This includes supporting approximately 3,800 homes that are currently in construction with support from those programs. In addition, in September of this year, we announced an initial pipeline of 185 preferred projects that will deliver more than 13,700 social and affordable homes across the country under the first funding round of the Housing Australia Future Fund facility and the National Housing Accord facility. We are now working with preferred applicants to finalise and enter into funding contracts in relation to preferred applications. For this to occur, applicants may also need to finalise their own contractual arrangements with landholders, developers, builders, other authorities, capital providers, and in some cases, other grant funders such as states or territories. Details of successful applications will be released in due course in line with the reporting requirements under our investment mandate. Our second stream of work is helping people access home ownership. We currently support this through the delivery of the Home Guarantee Scheme, enabling eligible home buyers to provide a smaller deposit than the lender would typically require. To date, Housing Australia has supported over 184,000 people to achieve home ownership, with over 58,000 home buyers assisted last financial year, including approximately 1 in 3 first home buyers who purchased a home last financial year. I would like to acknowledge the significant work of the Housing Australia board and team, past and present, in delivering these outcomes, and acknowledge and thank colleagues in Treasury, Finance and other departments that support the work of Housing Australia. Since joining with CEO, I've been working with the board and team to make sure we're using all the levers we can to support the delivery of more homes and support more people into home ownership. Whenever I see someone who's slept rough, or when I see the lines of people waiting for a rental inspection, or aspiring homeowners who are searching for a home, perhaps feeling that step is too steep to climb, I am reminded of the great privilege and responsibility of working at Housing Australia to play a part in supporting more Australians to access affordable, safe and secure housing. Thank you, and I look forward to your questions.
Thank you very much, Mr Langford, for your opening statement and for outlining all the really important work that Housing Australia is doing and why it's so important. Thank you. We'll go straight to questions, and I'll go to you, Senator Bragg.
Thanks very much. So, basically, the announcement from the Minister on 16 September 2024, which was called Albanese Government greenlights most social and affordable housing in over a decade. You know about this statement?
I'm aware of it, Senator, yes.
Yeah. And so the government, I think maybe the Prime Minister was even announced, he was involved with this announcement, announced that there would be 13,742 houses built as a result of this press release. Has this arrangement that's been announced by the Prime Minister been finalised yet?
Well, Senator, I won't comment specifically on the Prime Minister's press release. What I will say is that on the 16th of September, Housing Australia released information that though 13,742 homes had been identified as part of preferred projects in funding round one. As I said earlier, we haven't. We're now working to finalise the contracts for those projects, and so we'll release information about each of those projects in line with the requirements under the investment mandate.
Okay, so it hasn't been. So have contracts been signed?
Senator, one contract has now been signed.
Okay, who with?
Well, Senator, we'll be releasing the information about that in line with the requirements under the investment mandate.
So you can't tell us at the moment?
Well, Senator, I can tell you that we'll release the information in line with requirements under the investment mandate.
Yeah. Can I just... Is that right? Can you do that? We'll just check if that's right, if you can do that. Because I think you might have to...
I think possibly to assist... yes, there's a reasonable question, Senator Bragg, about whether or not the official's entitled to not provide that information in those circumstances, but it might be easier if he just takes it on notice at this stage and comes back with a response. Yeah?
Is that...
Yeah, Mr. Langford can take it on notice and consider what information he can provide.
Thank you, Chair.
Okay, so of the 13,000 houses that were promised in this statement back in September by the Prime Minister and the Minister for Housing, you're saying now you've signed one contract in relation to that?
That's correct, Senator.
Okay, and how many others are due to be signed?
So there were 185 projects identified as preferred applications.
Yeah.
And so we've signed one contract.
And how many... Are there 185 contracts?
I might just ask my colleague online, Ms Johnston, just to confirm, but Ms Johnston, are you able to confirm that it'll be 185 contracts?
Mr Langford, Rowena Johnston, Chief Credit Officer, I can confirm that there are 185 preferred contracts, so therefore 184 left to execute.
Thank you.
Okay. So a long way to go to finalise.
We're working through the contracts, Senator.
Yeah. And what type of organisations will be involved in these arrangements? Will it be community housing providers as well as other investors?
That's correct, Senator. If I refer to the investment mandate, eligible applicants included states or territories. It included community housing providers. It also included special purpose vehicles that included one of the other categories. There were some other categories of eligible applicants that included those such as an entity that has the primary purpose of improving directly or indirectly housing for Aboriginal or Torres Strait Islander people, or improving directly or indirectly housing outcomes for members of the Australian Defence Force. There are other requirements in relation to each of those in relation to them being charitable organisations. A special purpose vehicle had to be a constitutional corporation with one of those other categories as a member of that. Okay, and will any of these investors be super funds? Senator, my understanding is that a super fund in its own right is not a eligible applicant under the Housing Australia Future Fund facility or the National Housing Accord facility. But will they be part of the consortiums that will be bidding or have bid for some of these contracts? So, Senator, I'm not aware that there are any super funds that have been joined into a consortium. So, of the eligible applicants, we are aware that superannuation funds have provided some support through other vehicles to some of the eligible applicants, but there are, in their own right, they're not eligible applicants. Okay, so they're part of the overall proposition. They're not individually engaging with Housing Australia. That's correct, Senator. And how many super funds would you say are involved providing letters of support and the like? Senator, I'll refer that question to my colleague, Ms Johnston. I'm not sure if we have that information on hand, noting that relationship between the eligible applicant and their project partners is only based on information they may have disclosed to us in the application. Okay, well, but Ms Johnston, do we know the answer to that question?
Thank you, Mr Langford. Senator, we don't have that level of detail. The participation of superannuation funds is usually in relation to the subordinated debt structures within our projects, and we don't have visibility on that. That is subject to further commercial negotiations as we work through the projects.
Okay. So you don't think there's any, you're not aware of any super funds that are involved?
Senator, we're aware that institutional investors, which may include super funds, so for the avoidance of doubt, there's some aggregation vehicles that work with superannuation funds, have provided letters of support to applicants, but as yet, applicants haven't entered into arrangements with them, and we haven't finalised arrangements with applicants.
Yeah. Is CBUS one of those? Do you know?
Senator, I think we've checked in accordance with the question that you asked most recently, and we're not aware that, or there is no record that CBUS has provided a letter of support to any of the applicants that we're working with.
So when do you think you might actually get going with some of these houses being built that have been announced back in September? I mean, when do you think the houses will be actually completed?
So, Senator, the program target was to commence construction of 40,000 homes over 5 years. Out of the first round, we anticipate that a number of those will be either delivered or in construction during the course of this financial year. I don't have the exact profile of the completions and commencements this financial year, but happy to take that question on notice if you'd like that level of detail.
So you don't know how many of those 13,742 would be completed in this current financial year?
Ms Johnston, do we have any of that information on hand?
Mr Langford, we don't have the information to hand, but Senator, we do have a requirement within the eligibility criteria under the HAF program that projects must be able to commence within 18 months of contractual close, and also must commence construction or complete construction within 5 years.
Within 5 years? So some of these houses that have been announced back in September this year might not be completed until 2029.
It's better than nothing that happened in 10 years.
We built more houses than you, 220,000 houses a year. You're down to 160,000 houses. So I wouldn't go there if I was you.
This is the biggest investment in social and affordable housing on record, Senator
if you want to try and defend, if you want to try and defend the previous government's record, which was a record of neglect,
You're down to 160,000.
Zero meetings and engagements with the states. Zero.
More houses than
no
you.
cooperation. And
what's most important? How many houses you built?
Utter neglect. Tradespeople training fell off a cliff. Immigration system completely cactus. The fact that you can smugly sit there and assert that there was something good about that period when what it left Australia with was a completely constrained housing system. A completely constrained housing system.
220,000
and
more
this
than 160,000.
Almost zero social housing built. Almost zero social housing built.
About housing.
And this government, after delay from you and your colleagues, what has happened here is that the HAF legislation approved at the end of last year.
We don't agree with it.
Weeks later. Well, you don't agree with anything positive that's about building houses for Australians.
Well, we do.
And
we have a supply policy, $5 billion supply policy.
Okay.
The idea that neglect is a good policy framework, which is what your proposition
was.
It's like an arsonist complaining about the smell of smoke, Senator Bragg.
All right.
It is completely at odds.
We build more houses.
You didn't build anything. The private sector built it. You sat on your hands.
That's the measure that counts.
You sat on your hands.
All right, I'll see you, Senator Bragg. Okay.
Zero.
All right.
Zero.
Okay.
Zero.
All right. Okay. I'll just see if Senator Bragg has any more questions.
I'm being disrupted.
That's why we partner with the private sector.
Senator Bragg has any more questions before we move to the ABS.
I have many more questions.
Who we also need to go to. You did tell me you didn't have a lot of questions for Housing Australia, but you have the call.
Well, I mean, I'm trying to be as efficient as I can.
You have the call.
And ask the officials the questions. So, okay, so some of them won't be built until 2029. So it's quite a long time away. So thank you for clarifying that.
Well, that's not what the official said.
Said 5 years from now.
No, what the official said was that the contractual requirements require commencement to start at a particular time and require completion to occur at a particular time. That is not the same as saying that houses won't be completed in 5 years. That's the kind of smug political assertion that I expect from the coalition in this area where there's been utter policy failure for a decade and now a complaint that it's taken a little bit of time.
More houses
to
than
get
you. Thank you. Okay, let's move on. So let's talk about these institutional investors. So there's been a few FOI submissions to Housing Australia. One of them was in relation to a fund called Hester Super, where you have said in an FOI documentation that there are 16 pieces of correspondence between Housing Australia and Hester. So what are they about?
Senator, I'm going to ask my colleagues online if they have any information about that, but otherwise I'll have to take that question on notice.
Yep. Thanks.
Mr Langford, we don't have that information to hand, and Senator, if we can take that question on notice, please.
Okay. What about Host Plus? There's 3 pieces of correspondence with them. What are they talking to you about?
So, Senator, I'm not familiar with the correspondence, and I don't believe that the team have got that correspondence with them, so we'll have to take that question on notice.
Okay, so you don't know about those. Okay, I'll also get you to take on notice the 2 pieces of correspondence with CBUS, Super, and the 9,149 pieces of correspondence with CBUS Property, IFM Investors, Aware Super, BusQ, Care Super, Rest Super and Australian Super.
Thank you, sir.
I don't expect you to give an answer on all 9,149 pieces of correspondence, but I'd like to know broadly why they are talking to you as a government agency and what they're wanting from you. Because I don't think we've been able to get information through the FOI process. I want to ask you about the housing support program. Do you administer that?
The housing support program, Senator, I'm not familiar with that program, so I don't believe we do.
That's not Housing Australia?
No.
Those might be questions for Treasury.
Yep.
Okay, we'll ask those if we have another estimates before the election, which we imagine that we will. I wanted to ask you then, just about, there's a governance issue I just wanted to raise with you. Have there been any issues on the... Sorry, who's on the Housing Australia board?
The current board?
Yeah.
So I can take you through the board membership. The chair is Carol Austin. Other board members, Kathy Armour, Richard Wynne, Nigel Ray, Kelvin Ryan and Martina, whose last name I can never pronounce, Papanothopoulou.
Okay, fair enough. It's a good try.
Thank you, Senator.
Now, have there been any... I know you're only new in this role, but have there been any issues with bullying complaints in relation to the board which have been made to the Treasury that you're aware of?
Senator, we would encourage anyone who's facing bullying concerns to raise that, and would investigate in accordance with specific practices. I don't have any details.
So you're not aware of any bullying incidents inside the Housing Australia board which have been reported to Treasury?
Well, Senator, I won't comment on any bullying matters that are raised inside the organisation to protect the anonymity of people. We want them to speak up. I haven't seen any documentation that relates to the board.
Okay, so the answer is, I'm just trying to understand, are you saying there is one or there's not one?
So, Senator, if you're asking me if I've seen anything, then the answer is no.
Okay, that's fine. And there's no one else who could give any different answers, other you're the CEO, so I assume that no one else would know. Okay. Have you got 131 staff there?
Just give me a moment, Senator. You're talking currently...
At Housing Australia, yeah.
Currently, I think we are just up above that number now, Senator, because we've been recruiting additional staff. If you just give me a moment. Mr Lee, have you got that number in front of you?
David Lee, Acting Chief Financial Officer. Yes, Mr Langford, this total staffing number at September is roughly 170 full-time employees.
Okay. Yeah. So, okay. And you have a corporate affairs and government relations unit, don't you?
We have a corporate affairs team, Senator. Yes.
Yeah. Is that right? The number you gave us from the last estimate, is that accurate? That you said that the budget for 23-24 was $1.99 million?
Mr Lee, can you confirm that?
Yes, thank you, Senator. We provide that information into a questions on notice request, and that was correct.
Is that right? Okay. So what do you do for $2 million in corporate affairs?
So thank you, Senator. The board assigns resources to achieve the objects of the Act. Like a lot of government agencies, we have a corporate affairs function. It supports communication about our role and all the various programs. It covers raising awareness of the programs that we have, managing media inquiries, stakeholder engagement, corporate reporting, government relations and advice, and internal communications.
How many people work there?
At the organisation, Senator?
No, in corporate affairs.
Do you have that number, Mr. Chair? Senator, I believe we've got 6 ASL in that team, but Mr. Lee, can you confirm that? Otherwise, I will need to just take that on notice for confirmation, Senator, if that's okay, because I need to just check a current head count, if that's okay. Mr. Lee, are you able to?
Yes, Mr. Langford, it's around 7 ASL.
Beg your pardon?
7 ASL.
7 ASL.
Okay. Just finally, thank you for that. Just to clarify, so just with the question of notice you took before around the issue of the contract.
Yes, Senator.
I think if you want to file a public interest immunity claim, I think there's a process for doing that. But I think, effectively, we're allowing you to take it on notice, so you might want to consider doing that.
That's what
if you need to.
That's the process. Yeah.
Thank you, Senator, and apologies, I'm not familiar with some of these nuances.
That's great. Thank you very much, Mr. Langford and team. That concludes our questions. You go with our thanks. Thank you. I need to release this witness so you can ask questions of the ABS. So thank you. You go with our thanks. The committee welcomes representatives from the Australian Bureau of Statistics. And we welcome Australian statistician Dr. David Gruen and team. Dr. Gruen, did you have any opening remarks, or are you happy to proceed straight to questions? Chair. Okay, thank you. I'll go to you, Senator Smith.
Thank you, and welcome, Dr. Gruen and officials. Can you confirm for the committee which topics have been agreed to be added to the 2026 census, and which topics have been agreed to be removed, and which topics have been agreed to be amended?
Okay, a topic on sexual orientation and gender has been agreed to be added, and I might get Brendan Goldsworthy to fill you in on all the other details.
So Brendan Goldsworthy, Deputy Australian Statistician of Insights and Statistics Group. The government also agreed at our recommendation to remove the topic of the number of children ever born from the 26 census. The idea there is that the data need is for it to be collected every 10 years, so our intention is to recommend that it be included in the 2031 census, but it wasn't necessary to be included in the 26 census.
That is the total sum of the changes of the additions, the deletions and any amendments?
Yes, some language changes. Yes, there are some language changes.
Mm-hmm. And they are? I'm asking these questions because I understood that you recommended to government 5 topic changes.
That may, we can get the details on that. We will have them. I think I've got them here. I've got the recommendations, and the recommendations were accepted. So let me find them. Okay. Yep, that one. Right. Okay, so language spoken at home, replace the word spoken with used.
Mm-hmm. So I characterise that as amended?
Yes, indeed. So proficiency in speaking English, replace the word spoken with used. His or her with the persons.
So that's 2 amended?
Yeah. Would it be easier for us to just give you this list as a matter of...
No, because I want to go... I'm going to the point... I'm going to the matter of the advice that was provided to government and the decisions that were taken by government.
Okay, so those are the...
And while Dr. Gruen's doing that, I thought I heard Dr. Gruen say that all of the advice was accepted.
So the advice was accepted. There were some changes that the government decided on. So our advice had been to ask the gender question for all ages and the sexual orientation question for 15 plus, and the government decided to ask both for 16 plus.
Thanks.
Thank you. The matter of religious affiliation or religious identification has been, and we had an opportunity to discuss this in a private briefing a long time ago. Now, can you provide an update to the committee on how that matter is being considered?
Certainly, Senator. As you're aware, that's a decision for us, not for the government.
Correct. Yeah.
In fact, it was, I think, at the last estimates that I said to you in an answer that we were very keen to hear the views of groups that had an interest in this question, and I have had a series of meetings with a large number of groups, so we've heard their views about the nature of the question that they would like asked on religious affiliation. And just to fill out the answer, the main options are a updated version of what we did in 2021, which is to have a tick list with the most common answers from the previous census. That's one possibility, and the other possibility is to have a free text field and with the idea that people write it in. Now, so we have had those conversations with religious groups, something like 10 meetings, I would say, with different groups, both religious and secular groups, and we are close to making a decision which I think we will announce in the new year.
Mm-hmm. And just to clarify, topics are determined on advice to government by government, and the structure of the question is completely the authority of you as the Chief Statistician.
That's correct. Right. So the government, or actually the Parliament, as you would understand, these are disallowable instruments.
I'm coming to that in a moment.
Okay, sorry.
Yep.
The Parliament decides the topics, and it's left to the professional judgment of the Bureau of Statistics, and you're correct, ultimately to me, to decide what question or questions will best elucidate answers for those topics.
Mm-hmm. Turning now to the Census and Statistics Regulation of 2016. This is the regulatory function or mechanism that gives effect to the decisions that government has taken in regards to the topics to be included, excluded, but not amended, because that's a word change which is in your authority. I think
the word changes are also
in the regulation.
I think so.
Okay, yep. When will the regulation hit the Parliament?
They have been tabled in both houses of Parliament by now. I think the one in the Senate was tabled yesterday, or
maybe on Monday.
Maybe Monday, yeah. But the House of Reps was earlier.
Yep. So in a document that's available to everyone, it's a part of the OPD production of documents that was provided to the Parliament recently, and I suspect it might be the subject and publicly available through FOI and others. You identify a number of scenarios for the successful implementation of the 2026 census, and one of those documents this document here is called the Legislative Timetable to Support the 2026 Census Critical Pathway, and it explicitly identifies the possible interference of a federal election and being able to meet the legislative and regulatory timetable to give effect to the 2026 census. I wasn't aware that the regulation had been tabled in the Senate yesterday.
Monday.
Monday.
So I understand it.
How does the election timing interfere with the Parliament's consideration of the regulation, and how could it impact the preparations for the 2026 census?
You want to take that?
Yeah, so the disallowance period is 15 sitting days. So if the election is called before those 15 sitting days expires, then that interrupts the clock, if you like, and then it will need to restart following the election once Parliament has been recalled or the new Parliament has started. For us, the key date that I have in my head is passage or the disallowance period having passed by about middle of next year. So we're comfortable under either scenario. Election being called in, say, April, May will mean the disallowance period is met prior to the election. If the election is earlier, then there'll be ample time after the election.
So if the election is called for the 22nd of February, meaning that there is no, the first 2 weeks in February are abandoned and the additional estimates period is abandoned, and the Parliament comes back, let's say, at the end of March, the implementation timeframe for the 2026 census is still able to be met?
Yes, that's correct.
Right, okay. I do have more questions, but I'll defer to others, and if time allows, we can...
Thanks. Senator Roberts.
Thank you, Chair. Thank you for being here again. I'll just table this for my second question. First question is, referring to your comparison of all-cause mortality, you'd be familiar with this?
Broadly, yes.
And COVID deaths against baseline using regression data. Firstly, thank you for the analysis. It provides a clear idea of where we are. I note excess deaths are staying above the baseline, above the upper range of the baseline, and something the monthly provisional mortality data also shows has continued into 2024. My question should be familiar to you. Is the ABS doing enough to produce the wealth of data the government and our health agencies need to review their decisions during COVID? Specifically, why haven't you added vaccination rates to this data?
So the answer to that question is that we collect the mortality data we get from births, deaths and marriages from each of the states and territories, and it is not, it does not, I will make certain that this is correct, but my understanding is that that vaccination status does not come with that, with the births, deaths and marriages data that we get and publish. This is the publications that come out 2 months after the period. Is that the?
I think I'm not sure of the agency's name. I think it's the Australian Institute of Health and Welfare, or maybe the National Institute of Health and Welfare.
Australian Institute of Health and Welfare.
They are able to provide the vaccinations, I think.
Then they may well have done the analysis. So vaccination status exists, and it's, for instance, in our integrated data assets, and the Australian Institute of Health and Welfare does analysis on our data and produces reports. So I'm not saying the data doesn't exist. I'm saying it's not in the form that where we publish it. It's not in the form that we get from the births, deaths and marriages from each of the states and territories on which we base the mortality statistics that I think you're talking about.
Right. So isn't it just a matter of adding another data set, getting that from somewhere? Because this would be valuable information for our health authorities.
So the answer is that it requires analysis, and that's not what we do for that publication.
What about do the health departments and health agencies use your data?
Yes.
So wouldn't it be helpful to them to understand the vaccination rates?
So I think there's been quite a lot of work on vaccination status and the implications of vaccination status for mortality. There was a very big study published in The Lancet that was done by the University of New South Wales, which looked at that. So followed 3.8 million Australians over 65 in 2022. So there've definitely been studies.
Okay, let's move on. The document I tabled, or the scientific paper that I tabled, Melbourne University has done the work that you haven't done, and they've used regression analysis to test for the relationship between COVID boosters. If you have a look at the abstract, it's some...
the document.
Yeah. If you have a look at the abstract, it summarises what I'm saying. I've circulated their paper, published by the European Society of Medicine. This is their conclusion, and I'll quote, "The results suggest a strong regression relationship with an adjusted R-square of 71%. Correlation of 0 is no correlation. 1 is a perfect correlation." In this paper, they found a correlation of 0.71. That's very strong, and it suggests the boosters are linked to excess deaths. As you already do this work, that's the graph again, why won't you just add vaccinations and boosters to the data and give the Senate better information upon which to base better decisions?
Well, I've already answered that question.
Yeah, I wasn't happy with the answer.
So the point is that
you haven't explained it.
The data comes from somewhere else.
Why can't you do that?
I explained that those data come from births, deaths and marriages from all the states.
I understand that.
Right? And so the vaccination status comes from elsewhere. It comes from the Australian Immunisation Register.
So you don't merge two together? You won't do that?
Sorry. We publish the data that is available to us. Others do analysis on that data. It is perfectly open to anyone who has a well-defined project to use the data that we have generated and to produce research on that. That's completely up to them. We are an organisation that produces the data, and it is predominantly others who do the analysis.
Okay, so you take data from various agencies that collect it, you summarise it and present it. Other people use that data to do the analysis. Yes, there are circumstances where we do some analysis, but in this case, it's others who do the analysis on linking vaccination status and mortality. Okay, thank you. Coming to Australia to work, I'm changing the topic. Coming to Australia to work and send money home is something I hear often as a reason for people moving to Australia to study. I'm curious about how much money leaves the country from students sending money home. Your publication, Recording of International Students in the Balance of Payments, has a lot of data. I couldn't find the specific item, how much money is sent home. Can you tell me then, please, how much money is remitted from Australia each year by international students?
Let's take that on notice. I don't have it in my head.
Okay. Moving on to the 2026 census, referring to the table cited status of potential new topics on, it's on your website, status of potential new topics. Sexual orientation for children aged 16 and up is listed as a new topic. Is that correct?
Sexual orientation for people 16 and over.
Yes. To be included in the, says sexual orientation to be included in the 2026 census for people aged 16 years and older. It's in...
That's right. That's correct.
Okay. Families fill this form out together, I'd assume.
Say that again, sorry.
Families would fill out the census together?
That's often the way it's done, yes.
And can see each other's responses. So are you, the question is, are you exposing a child to a conversation they may not be ready to have with their parents, or which they may not be ready to have with themselves yet?
That's an important issue, Senator. The way that we handle this is that for these forms, a household form, there's always the option of prefer not to answer. So that is an option for these sensitive questions. And the other important thing is that if a young person living in a household chooses not to discuss this with their parents, but wishes to record answers that they do not wish to share with anyone else, they can fill in a private form, and we will override the answers that they provide so their form will take precedence over the family form.
Wouldn't the other members of the family know about that? If someone was reluctant, if a family member over 16 was reluctant to answer, then that might start a conversation that no one's ready to have.
And this is basically your last question, Senator Roberts.
So, you know, what business is it of the ABS to know the sexual orientation of children?
Well, so the answer is it's not our business. The answer is that we provide the option for people to fill in the form privately without having the conversation with their family, and if they can choose to do that or not do it. And we have an option in those questions of prefer not to answer. So we have done the best we can to provide an environment where people do not have to reveal this information if they would prefer not to.
But just having the question there, excuse me, Chair, I'm just following up on that.
Senator Rennick, we've got 3 minutes.
Well, I just want to follow up on that question.
Senator Rennick.
Okay. Hi guys, how you going? I put in a question on notice in the excess death inquiry asking for if I could get a list of the deaths in 2021 and 22 along with the vaccination date and date of death. And the reply I got from the ABS was that I'd have to pay $40,000, or its estimated cost of about $40,000. Why should I have to pay $40,000 as if it's a question on to a Senate inquiry? Why does the ABS charge $40,000 for data regarding vaccination status and date of death?
Right. So as you're aware, Senator, we put a vast amount of data for free on our website. We have about 500 statistical releases a year, all free on our website. So there's a huge amount of information on our website. We also have a secure environment where we have de-identified sensitive data where researchers, after they have signed an undertaking that they will respect the nature of that data and will not attempt to re-identify, can come in and do research on that data.
So can I do that? Can I get access to that?
So I think, well, you have been in discussions with us about whether you could do that, and we have been talking to you about the conditions under which you can do that. One possibility is that you do it through our consultation service, and you've been in discussions with the consultation service about the possibility of doing that. If you wanted to do it yourself, we need an assurance that we're dealing with someone who is a sophisticated data user who knows what they're doing in big data assets and understands the computer coding that will need to be done. So that we're not having separate rules for you than for anyone else. These are our global rules, these are expensive assets to maintain.
I accept all that, but I mean, I would have thought it's in the national interest to answer questions from senators in Senate inquiries, and the particular query that I'm asking for, I don't think is a very big one. I mean, we can cut it down 172,000 deaths. It's not a huge database, 172,000.
Just a quick final comment, Dr. Gruen.
So the answer is we engaged with you about this, and our consultation service gave you a sense of what it would take to answer those questions.
Thank you, Dr. Gruen and team. It being 10 p.m, the committee stands adjourned. Thank you.